404, Ms. So-and-so submits that the instant revision application is connected to CRP number
PDS number 69 and 74.
4/2025,
Oh.
which is fixed on 25,
April.
which is fixed on 17/3/2025. She therefore submits that the instant matter be also taken up on that day. Taking into account the ministry is directed to list the instant revision application along with CRP number 70 on 17/3/2025.
I mentioned a leftover matters for orders next to any date. This matter relates to lots of releasing of money in MSC. Next to any date.
28 March.
Number 90, my senior has become canvas. We have also taken the consent from the other side.
Wait, which item?
Item number 90.
Oh, no. This matter has been going on from 2023 and every time you have been seeking adjournments. Enough is enough. Mr. Sharma, you are there in this matter. Too much of adjournments have gone in this matter.
May I please also pilot? I wish to mention item number 38. My learned friend is appeared today, my lord, and filed the affidavit in opposition. Number and affidavit law. Today, my lord. I have received just now.
38 what?
38, my lord, my learned friend is appeared today, my lord, and filed the affidavit in opposition, my lord. Just received.
CRPIO.
Yeah.
You are filing affidavit in opposition.
Filed
What is this affidavit in opposition for?
for the respondent number 1.
Why?
Bring certain facts on record which are already actually not in record.
What are you challenging here?
My lord, they want to find a written statement. And the time has come. After 5 years, they have come.
No affidavit is required. We won't look into this affidavit. We will only take what you have stated. Okay? So no reply business. We'll take up the matter.
Of last month. But she will take it up today. Yes, last month.
This type of matters should not be. Yes, Mr. Sikdar.
Paying for you, other intentions to pick up the matter and listed item on Tuesday from day after tomorrow.
Why?
But the case is fixed, my lord, on 13th. So we are against some interlocutory order of the trial court.
Okay. Finish.
May it please your lordship, I beg to mention for listing of an RSA lordship for withdrawal.
It's Wednesday.
Right.
Yes, Mr. Bhatti, what are you challenging here?
My lord, I am challenging the order dated 22. Yeah, 22nd January. Whereby my application was disallowed in part.
Which order are you
Regarding
challenging?
At page 16.
Page?
Page 6. Page 16, 16.
So what is wrong?
My lord, so far, using the tendency of the suit file or using the tax, I have to prove that I am not the defaulter.
No. You see, the plaintiff categorically says that we have no objection in only you are to prove as regards the defaulted period.
Default.
Okay? So that is what has been allowed.
That is allowed, but subsequent period too, by the way.
Subsequent periods not necessary. Subsequent, Mr. Bhatti, subsequent periods are not necessary, taking into account that they have to file an application in terms with Sobha Bishwas. Sobha Bishwas, there is no application filed by the plaintiff to that effect as regards the subsequent period. So under such circumstances, not necessary. Withdraw, dismiss, which one?
That is a different thing, my lord.
Which one? Mr. Bhatti, which one? Withdraw or dismiss?
My lord, in that case, I would do it, but
Withdraw.
I'm going to
Mr.
submit,
O.P.
my lord.
Bhatti. No, Mr. Bhatti, nothing. O.P. Bhatti, the Learned Counsel appearing on behalf of the petitioner submits that the petitioner would not like to press the instant petition. Accordingly, the instant petition stands closed on withdrawal.
But
Yes, Mr. Khatania, what are you challenging?
I didn't bid order, my lord. My evidence was once on the ground that I could not answer a question put by the court.
Huh?
I could not answer a question put by the court. That's what will kindly say at page 21.
Page 71.
So it was put by the court. And I could not answer. Ordered down my evidence was expunged. 71. Alien person is 72. And the propensity is present before the court along the witness, knowledge to jury. Petitioner under an MD so has filed a petition with the prayer to fix under the for submission of PW3 by showing law, which is seen and heard and allowed. PW1, the potential that is present in the taking oath, he is asked whether he has submitted written evidence on affidavit before the court in connection with the case. Plaintiff replied that he has not submitted his written evidence on affidavit in this case. Thereafter, the court again asked the witness whether he has submitted his written evidence on affidavit in connection with the court particular language. Yes, but they said it is stated in open court that he has not submitted any written evidence on affidavit, but his engaged counsel may have filed written evidence on affidavit.
So what is wrong?
My evidence was expunged.
Absolutely. If he comes to the court, where court shows him that, did you file this? You say that no, nothing remains.
Because of his ignorance, maybe that he might have committed some mistake in answering the question. So other side. would
Don't
say
you think that this is a fit case for calling that witness out here before the court?
That witness.
Yes.
It was please because but
Because he
Then-
himself says that I did not do. Why should we interfere later on?
the other hand, he said that yes, my advocate might have filed. Maybe because of ignorance. The case prejudice because the entire evidence was. This is the PW number 1. And subsequently also I filed an application. Page 73, that was also there. And he was the main witness. Other side may cross-examine him, that is differently, but question was.
This is not a case to revise. You made a mistake, you made a mistake. How can I help it?
The other side, they will cross-examine and they'll cross-examine.
No, where is the question of cross-examination? You do not, without there being a chief, where is the question of cross?
And on the other hand, also consider that he also said that yes, my advocate might have filed. Maybe because of ignorance, because.
No, but then also the court asked him, did you file this one? In Assamese also. Then also he didn't
Yes.
understand.
Usually we also ask that person first, being the adverse party.
No, isn't it, Mr. Khatunier, the requirement that an examination in chief is no evidence? An examination in chief has to be, that person has to come before the doc and say that this is my document.
That I
And if he says that this is not my document, then obviously nothing remains.
ultimately court will decide what is the impact of that. Answer. Court may decide. At least also can be some time to.
For what? How do I revise this order? Say that this is wrong. Tell me.
Let the court consider. Like,
How? You file a review application. Whatever
So
may
we
be,
have already-
ask that person to go, the court may accept it. I am not going to touch this order.
Policy 73, page 73. We file an application.
You
After
filed
that,
an
yes,
application, nothing remains.
that also.
I am not going, the court is absolutely right. Who was the person who went there? Who is PW1?
PW1, the 20 himself.
Huh?
20 himself.
What is his age?
Yes. Yes is that one of the defendant was his tenant. And he filed a suit for the tenant.
Why there is no age? Where is his affidavit
Yes,
in support of his
65.
area evidence?
65.
Huh?
65.
No, page 33, there is no plaint. The entire plaint has not been enclosed here. That means,
35.
are you saying that you have filed a plaint without an affidavit?
Hey.
Yes. The plaint has to be supported by an affidavit. Kindly come to page 33. Is the verification. Where is the 34? You are saying about 90 years. He is 63 years.
Irrigation, yes. Everything is not enclosed. I think it is clear.
No, no, you, Mr. Khatunia, you are saying that he is 90 years. Didn't you say? He is 63 years old.
65.
63.
Presently he is
When did he become 65?
also will find at page 18.
When did he become 65?
Page 18.
And why is it taking such a long time for his evidence to be completed?
No, he was present on that day.
Then?
On that day, he was present.
Which
He was
order,
the,
which order you are assailing page?
page 71. On that day, he was present, and that person was put by the court, not by the other side.
So 27-2, he filed his evidence on affidavit, the examination in chief in 2023. And in 2025, this evidence has been cross-examined.
He was present on the day for possible.
What is wrong with the trial courts? No, this is not a ground. This is no ground.
He was present, but he answered the question that the wrong method. And he also said that the applicant might have filed maybe because of his ignorance. Since he was 65 years old, probably he could not have understood the question.
Why? He was also asked in Assamese. Then, and he has given evidence on affidavit, such a long evidence on affidavit. Huh? It runs into how many pages? How many pages it runs to? Page. One.
It is prepared by advocate.
49 to 70, 49 to 70,
to
20, 22 pages of affidavit he doesn't know.
by-
Then?
Okay.
Heard Mr. P. Kapil, the next council. An application filed under Article 57 of the Constitution challenging the order dated 27 to 2025, whereby the learned trial court had expunged the evidence of PW1 on the ground that when the PW1 had appeared before the court to face the cross-examination, he had specifically stated that he did not file any evidence on affidavit, any examination on chief by way of an affidavit. And he further stated that he did not know as to whether his lawyer had filed such an affidavit. Because it is a tried principle of law that an examination in chief by way of an affidavit is not an evidence, and the witness has to appear before the court and state that the examination in chief has to, the witness has to enter the witness box and state before the court or the commissioner duly authorized that the examination in chief by way of an affidavit is his. Has to own, is his or her. Because in the instant case, as the examination in, as the plaintiff witness number one failed to do so, this court finds no ground to interfere with the order dated 27/2/2025, passed by the learned trial court of expunging the evidence of PW1. Be that as it may, the petitioner hearing is given the liberty to file a review application before the learned trial court, seeking a review to the order dated 27/2/2025. And before parting with the record, this court further finds it relevant to take note of the submission of Mr. P.K. Khatunia, the learned counsel, appearing on behalf of the petitioner, to the effect that the petitioner was not shown, the learned trial court did not show, did not inquire with the PW1 as to whether the signature appearing in the evidence on the examination in chief by way of an affidavit was the signature of the plaintiff witness number one. This submission cannot be taken into account by this court. However, liberty is given to the petitioner to file an application seeking review, and the learned trial court shall consider the same in accordance.
She shall not be influenced by any. She shall not be influenced by any observation made. Otherwise,
Without being influenced by the observations made by them.
Item 3.
Yes, what are you challenging?
Lordship may take page 63.
Page
63.
63. Is this?
Para 12. Seventy-one is para 12.
Hmm? Yes.
No, this is not correctly interpreted. MP, Lordship may see para 9. Because jurisdiction is barred as per this order. This order that has been referred to, as per that, the jurisdiction is barred, para 9. And second, my lord, learned NCLT, both learned NCLT and honorable NCLT have exercised their jurisdiction and past orders. So there was virtually nothing left for the learned lower court to adjudicate. Para 9.
Enough?
Para 9. Next page.
What does it say differently?
Yeah. The 12 says, considering the facts and circumstances of the instant case, it appears that exclusion of civil court jurisdiction cannot be readily imparted on the ground of availability of remedy and forum under a special act. The decision of the Honorable Supreme Court may be relied on this regard. Honorable Supreme Court says where the statute gives a finality to the orders of the special tribunal, the civil court jurisdiction must be held to exclude. Here, my lord, Honorable learned NCLT and NCLT both have passed orders.
What is the plain? Where is the plain?
Yeah, my lord, page 48.
What are you asking for?
page 40. Prayer is at page 52.
Where are the prayers?
Prayer is page 52. Page 52.
Decree for
Mary.
declaration that the suit property is joint and undivided property of the. Decree for declaration. Assignment. Can the NCLT cancel the deed of the assignment?
It was considered. It didn't cancel the assignment.
No, no,
It
can the
considered-
can the NCLT cancel a deed of assignment?
No, 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 Milord. So that was prayed, Milord.
Huh?
But this is one prayer which the honorable court can actually, but not the issue of shares and the division of properties of companies.
But
Because
can
Milord,
can it be partly barred? Can the suit be partly barred?
partly part.
How?
But come to schedule. Come to schedule. Next.
Understood. How a suit can be partly barred?
Yes. Says Milord, there are three companies. Properties are belonging to the companies. Number one. Number two, it says either divide the properties of the companies or divide the shares of the company. Now, Milord, properties of the companies can be divided only by liquidation of the company. Now, that part has been delegated to IBC and jurisdiction is with learned NCLT, Milord. It is not even part of company law. It is IBC. So that is one. And division of shares, Milord, can be done under section 58 and 59 of the Companies Act, which has already been done. Learned NCLT, your lordship may come to
But
the.
here, what they are asking is for the properties.
Yeah, the properties belonging to the companies. They have written, Milord, in the schedule.
Whatever may be, but what is the declaration sought for? The declaration that the suit property is joint and undivided properties of the plaintiff and the defendants.
Milord, company law, your lordship may
Yeah.
appreciate this.
Here the
Companies
company,
are
here the,
having
co-
legal entity.
here the
So I
company,
am the shares, I am the
But
shareholder. They
Miss-
are also the shareholders.
but Mr. Counsel, here the company is not a party.
Company is not a party.
Then
So, Milord, but companies' properties, how can lower court decide without liquidation? I am asking a question to myself.
Hmm.
They are themselves saying that all these properties are part of Mahalakshmi Tea Company Limited, and Mahalakshmi Tea Company name has been just changed, Milord, to Mohijuli Tea Companies. Now, all these properties are belonging to Mohijuli. Now, if these properties are to be divided as Milord joint family properties among the members of the same family, the company has to be liquidated. And that can be done only under IBC. And that jurisdiction is Milord learned NCLT.
and what about the these lands which have been mentioned? Property number one is of the tea state.
Yes,
The tea state.
all belonging to the tea estate in the name of the company, Mohijuli Tea Company Private Limited. Earlier it was called Mahalakshmi Tea Company Private Limited.
And what is this property number three, Raman Properties?
Raman Properties is in the hospitality business. Milord.
Then
So it is a limited, it is not even private limited. First two are private limited, the third one is the limited company. All three are not parties in the suit.
and what is property number two?
Property number two is Mohijuli, Tejalpati Tea Private Limited Company. They have written, Milord, the last kindly year
No,
lord.
they don't mention it to be it's a company.
Yeah, last Milord, page 55. To all the equity shares of the Tejalpati company. Tea company.
Tejalpati Division Tea State.
Yeah.
They don't mention this to be a company.
In
Where is
the,
it mentioned?
at
that
the top, Milord, they are only writing Tejalpati Division and Tea Estate, but at the end, they are writing all the equity shares of Tejalpati Tea Company Limited. Milord, all these properties are belonging to the Tejalpati Tea Company Limited.
So there are two aspects. You see in the plain,
Yes,
kindly see paragraph 3.
yes.
Where is it mentioned that this it falls in the result of the two company.
In the plaint, they have not mentioned, Milord.
Right.
Only schedule discloses this.
After some time, the volume of being expanded and we have some monthly listed and results there.
Key estates are mentioned. The
Private
Lordship may
limited
read para 5, para
venture
6.
and by dissolving the partnership, we will mention that all the information.
The business, Milord, it started as a partnership firm and then it got converted into that company. And on the basis of valuation, shares were allotted to all the families.
Don't see anything wrong in the order. When a court is dealing with us in a preliminary issue, the court has to take whatever averments made in the plaint to be sacrosanct. In the plaint, it has been mentioned that these are individual properties which were being purchased by one of the persons. And after that, it was put into a partnership firm. And thereupon, on account of tax planning, it was brought into a company.
Correct.
But it always remained as a family company. It was a joint family property.
Correct. But
So if that
Company-
is so, then how can you readily infer that there is an implied bar or that implied bar has that there is a bar? It will depend upon the facts which is to be adjudicated at the trial.
Milord, if the properties are transferred from partnership firm to company, company is a legal entity, Milord. On the basis of valuation, the shares were allotted. That is an admitted position because they're also writing that divide the share. Either divide the properties or divide the shares. Now shares have already been at issue of
Where is that prayer that either divide the properties or divide the share?
that is in the schedule, Milord. Because
No,
both things cannot
where
be
is
done.
the or? Where is the or you are?
That is correct.
You want to bring it?
But how can it be done? Because this is not an investment.
I think Supreme
Your
Court may
Lordship,
help you.
kindly see the order first, NCLT and one Supreme Court order
No,
before passing any order. Milord. Kindly see NCLT order. Milord.
no.
It has already decided the issue of shares.
Where's the Supreme Court order? Let's see that. Which order? We are referring to Supreme Court.
Sasi Prakash. Para 5. And 6.
What is the trial NCLT deciding?
Yes, page 153. Identical order for the other companies. I'm just reading para 11. Page 153 is the order starts, learned NCLT order. The Lordship may come to para 7 of that order at page
Who
171.
is the petitioner here? Who is the petitioner here in the before the NCLT?
For NCLT, there are two petitions. In one company, Rahman Properties, the respondent, and in other two companies, I am the petitioner.
No, who is there in the before the NCLT? Who is the petitioner there?
Same, Milord. Petitioner. NCLT, there are two petitions. First, see this one, Milord. This has been filed by me.
Oh, means
Mohit
you are there.
I am there.
You are
And in the Rahman Properties, the other one was there. That was also dismissed. May I show that first, Milord?
no. You are appearing today for Anjana and Afroza.
Afroja. Azana and Afroja. Yes.
Afroja.
Azana, yes.
And they were the petitioners in the NCLT.
NCLT. One of them. Yes.
So these petitioners sought for 241 and 242 of the Companies Act and 397. Means mismanagement, it is mismanagement,
Yes.
operation and
Yes,
mismanagement.
yes. Now it is 241, 240.
Now, who is running the affairs of the company?
They are running the respondents are running the affairs of the two companies.
Who?
Mohijuli and Tejal Patel.
No, who is running?
Respondents.
The plaintiffs.
Plaintiffs, yes.
Plaintiffs are running the affairs of the company.
Three companies. And I am running the hospitality
You are running the hospitality.
hospital. Rahman property. That is schedule property schedule 3.
So here, you are asking for mismanagement in respect to which companies?
First schedule 1 property and schedule 2 property. That is
Not the
Mohit-
schedule 3, not the schedule 3.
Not the schedule 3, because schedule 3 already dismissed. Schedule 3, they went to before the NCLT, despite filing this. They filed this Milord civil suit, then also went to civil NCLT. NCLT dismissed that petition. I'll show that order.
No, it's okay. Now, where will they go?
From there, they went in appeal. Honorable Supreme.
No, I'm not on that. Let us assume that the schedule 3 has been dismissed. You are holding the rights over schedule 3. Okay. NCLT dismissed it. That there is no operation and mismanagement.
Correct.
And then they filed an appeal, the matter has
Yes,
gone.
that was filed after 10 years. The issue of transfer that
So
was filed.
thereupon, now they have filed a suit.
They have filed the suit. Before going to NCLT, they filed this suit in 2015. Then they went to NCLT. So all payers are almost the same. You are seeking your shares before the NCLT. NCLT says you are not the shareholder. And the same issue of shares is going to be decided also by the learned court under this.
So your petition has been dismissed,
My petition has been dismissed on the ground of
that you are not a shareholder of
no, no,
Mozumi.
no. I do not have a successor certificate. And that has been set aside by Honorable NCLT, saying that legal representatives are already into the shoes of the deceased persons, and therefore such petitions cannot be dismissed. That is a settled law. Worldwide agencies, my lord, that order has been referred by the Honorable NCLT and also their own order. And finally, it has been remanded to the learned NCLT to pass a final order. That is page 195, Honorable NCLT order.
One
195. Both the petitions got clubbed, 14 and 15, and a combined order was passed. TP number 14 and 15. This order has been referred.
So the NCLT file is there.
This order has been referred, my lord, page para 23 to 26. It settles this is that legal representatives are in the shoes of the so 241, 240, 242 petitions cannot be dismissed.
And what is the stage of the suit? Stage of the suit?
Evidence
Of?
PW.
What is this petition number 3917 of 2023? But the NCLT matters are on operation and mismanagement,
Yes.
which have no relation as regards this partition.
Partition can be done of a private property, not a property vested with the company. Because once the properties get vested in the company and shares are allotted, then they are shareholders. They are no more the owners. Because company cannot own the properties and also shareholders cannot own the properties. Shareholders are only shareholders. They do not have even an insurable interest in the properties of the company. Companies are legal entities. They are the owners. Independent from the shareholders. Because I can transfer my shares and tomorrow Abhijit will become the shareholder of that company and he'll run the company. I cannot sell the properties of the companies. Only companies can sell. I may be authorized as a director to sell that property. But I cannot sell the properties by my own as a shareholder. I don't have any right in that. That is the issue, Milord. And now learned NCLT has already stated that my father's shares, who died Milord on 13/11/2012, and my grandmother's shares were not transmitted by them. They are holding it.
Well, that I'm not concerned,
Yes.
but the NCLT.
Yes.
does. NCLT has only touched on the issue that these people cannot be said that they have no right, taking into account most probably in the articles of association, there must have been one of the clauses that they are also the legal representatives also will be the shareholders to the effect.
Yes, so
They have a right,
so they
which
will
is
say-
normally there in all.
They
the
were shareholders.
articles.
They transferred their shares by taking 4 crore 10 lakhs from my father. That is before 13 million. And after my father died on 13/11/2012, they, came in control of these companies, my lord, and started this dispute started there. It is also admitted in the plaint. It is admitted that they have accepted. There are so many documents, my lord. They have signed affidavits. They have signed declarations. Declarations, and your lordship may see your lordship's order, one order in which it is mentioned. That is 135 minutes. Page 130. Order of this honorable.
What do you say? Is an injunction.
That issue that they have taken money that has been dealt. I'll just.
This is only injunction. How can they be getting finality?
No, not finality. It is an observation of this honorable court.
Then
that they have-
observe, Mr. Srivastava, whether an observation being made in an injunction proceeding would be binding.
No, not
So,
binding.
then-
It is an observation of this honorable court. What I am saying, Milord, that learned court has authority to decide whether deed of assignment dated 8/3/2007 was acted upon or not. This is definitely because this is an issue of contract. Learned court has jurisdiction to decide, but not the issue of companies, Milord, because companies can be the properties of the companies can be divided only by liquidation, which is a part of now IPC proceeding, Milord, not even of Companies Act.
But IBC is not taking up that issue. IBC is only taking up, it is only a case of operation and mismanagement which is going on.
Nobody has gone for liquidation of the company. We have only gone for the operation and mismanagement. That there is a dispute of shares. They raised the issue of dispute of shares. They are lost up to NCLT. I also lost at the NCLT, Milord. Finally, I went to NCLT. NCLT says that you cannot dismiss the petition on this ground that they do not have a succession certificate. So you have
But the issue before the NCLT is completely different.
shares. Shares, Milord, not properties. Because
No, it is-
properties do not belong to
It is not on shares. It is on the question of operation and mismanagement.
So if my shares are transferred, it is part and parcel of operation and mismanagement. Milord. How
Whatever
can I
may,
be appraised?
whatever may be, Mr. Srivastava, the question is, the matter before the NCLT is only for operation and mismanagement.
Yes.
Let us not confuse with
Yes.
this. On the other hand, it is the case of the plaintiffs out here that this was a particular, this was initially purchased by so and so. And after that, it was purchased. Later on, it was after his death, it was made into a partnership firm. And after it became a partnership firm, on account of expanding of the business, we transformed into a company.
Yes.
And thereupon, now the company was going on, but otherwise it is like a joint family business. This is what is their case, and as such, they now see that declaration be given thereby to divide these shares in this regard.
Correct. So the moot question, Milord, legal question, can a declaration be given by the learned lower court to divide the properties of a company, which
Company
is a
is not,
legal entity?
company is not a party.
So there cannot be a decision against the company, Milord. Now somebody, two shareholders or two litigating person are going and saying, divide the properties of this company, company is not a party.
If the company is not a party, the
Yes.
suit may be bad for non-joinder of necessary party.
No, but also jurisdiction issue is there.
Now, how does the jurisdiction come into the
Because
picture?
they themselves are saying, Milord, that these are companies and they themselves are saying that shares are there in these companies and shares should be divided.
They are not asking that. to
That
get
is
paid.
in the petition.
Wait,
They are
wait,
not
no,
asking.
no, miss, let us not put words out there. You see, there is a difference. At the end of the trial, you may win the case. There's no quarrel with that. You may win the case. But the fact that as of now, when we are dealing with an application for disposal of a suit on a preliminary objection, we are to take into account that whatever is stated in the plaint is sacrosanct. So if that be
Yes.
so,
Yes.
if that be so, there is no relief being sought for to that effect. You see, that is the problem with which is disturbing the sport. I would have understood at the end of the trial, you will win it because they cannot. Without the company being made a party, they could
Right.
not have proceeded with the suit.
Right.
But it is a case by which it cannot be dismissed as a preliminary objection as a preliminary issue. It has to be decided at the trial of the suit.
Now, there is a difficulty with your lordship may appreciate. Now, suppose this court decides that the properties of the companies can be divided under this suit.
You may go for it. It does not without
Yes,
no
but-
you without the companies being made parties. The suit does not disclose a cause of action. It may be a different aspect, which you may have a case on that aspect if somebody argues in that manner or something. But to decide as a preliminary objection or issue, it is a difficult aspect.
My lord, may I assist your lordship one last? Now, if I file a petition by saying that unless companies are made a party in this petition, this suit cannot be decided.
No. You have to file a petition to get this suit thrown out at the initiation is on the basis of Order 7 Rule 11A.
Again, it becomes
It cannot
a
disclose.
preliminary issue. Your lordship
No,
may
it,
appreciate.
it won't be a preliminary issue. For the purpose of deciding a preliminary issue, the court has to take it as it is. Like in a plaint also, it has to be taken as it is. There's no quarrel, well, rejection of the plaint. But in this rejection of a plaint, can there be a disclosure of a cause of action on a reading of a plaint when a property is actually belongs to somebody else?
Correct.
That might be therefore a case under Order 7 Rule 11A for rejection of a plaint, but
that is
not for a purpose of the preliminary objection.
My lord, issue only, the last issue which is in my mind. The moment I file 711 and say that you have not made parties to the company, therefore this suit cannot be decided. Now, if the court comes to, because again, the 430 will come into play. It cannot be thrown out. The moment company becomes party, my lord, in 711, 430 of the companies that will come into play. That look, I am the companies. My properties cannot be decided by the lower court. Section 430 to 30 is the bar. It will come again. And your lordship have just read the Honorable Supreme Court. It will come again. Now the court may say that we do not agree with this. The same order may be passed because this is how the order has been passed. Without your lordship may appreciate.
No, you see, there is a difference. You are going into the question of jurisdiction.
Yes, my lord.
You are a question on a jurisdiction or is a preliminary objection. The preliminary issue, if it is framed, the preliminary issue has to be decided. Therefore, I am saying one has to accept what is stated to be true.
My lord. Yes, absolutely.
You have not got. Therefore, I am saying your case would not come under Order 7 Rule 11D.
Yeah, that is correct.
Because there is no bar. You see, there is no bar on a reading of the plaint.
Yes.
But it may not disclose of a cause of action in view of the fact that the property is of somebody else. It may be a case under Order 7 Rule 11A, but not 11D or even under Order 14 Rule 2.
Your lordship is technically absolutely correct. But the issue is, again, the crux of the issue is the jurisdiction. Even if I file 711, even lordship may ask me.
No, not.
Correct.
I would never
Go
say
back
to
on
you that
711
you
I
file
pass,
an Order
but again, the issue of
711P.
430 will only arise before the court, and court may say that I have already decided that 430 is not a bar upon me. Even if you say that a company has not been made a party, 3 companies are there, 3 companies are independent companies, they are legal entities, they are not made party. But I have already decided 430. If your lordship may read the entire order, how the order is structured, that is my problem.
No.
Because by referring the same order,
you see, I have referred to paragraph 12, 13, and 14. That is what the court decides.
yes, that is the final.
You see, here he says that he is asking for a declaration of something. As regard, kindly see paragraph 13, page 71. Say that he is asking for some declaration of something. As regards cancellation of deed of assignment and all, which is within the jurisdiction of the trial court. That is what it is. But the fact remains, whether this deed of assignment can under no circumstances be set aside by the NCLT or not.
Absolutely.
But the fact that if you are saying that can this property be divided without the company means there is no cause of action it would not disclose a cause of action unless there is something to that effect. The company being there.
That technicality is absolutely damn correct.
No, if that is there, but to take it that it is a preliminary objection, preliminary issue, it becomes very difficult. Right from 1964, the Supreme Court has been clear on this aspect. You have to take whatever is stated in the plaint to be sacrosanct. Means you cannot add or subtract anything while deciding a preliminary issue. Very difficult. I can issue a notice for your satisfaction as you have come all the way from Calcutta. But nothing more than that. But it is not going to help you out. You have a big problem there.
Technique 711. I agree.
Therefore, I would say you may not have a case directly under Order 7 Rule 11D, But if you add Order 7, Rule 11A, and without being disclosure, and if disclosed with the company, then it bar under 11D. You may have a case, there, but not in this. You should notice.
Great.
You notice. Why is one person not there? Only two.
Only beside other
You
process.
should notice making it returnable on 7th of May 2025. Steps be taken upon the respondent numbers 1 and 2 by way of registered as well individual. The petitioner is given the liberty to take steps by way of the related to the registry of the spot and file an affidavit of service on or before the next date. The petitioner herein have assailed the order dated 5/12/2024, passed in title suit number 305/2015, whereby the preliminary issue which was framed on 21/8/2024 by the learned trial court as to whether the suit is barred under section 430 of the Indian Companies Act 2013 was decided against the petitioners who were the defendants in the suit. Mr. A.K. Srivastava, the learned senior counsel, assisted by so and so.
I'm not seeing.
Okay. Srivastava, the learned counsel submitted that the company, that the property which is the subject matter of the suit belongs to three companies. That is the Mozili Tea Company. Mozili
MOHI, JULI, Mohijuli Tea Company Limited, and another is Tejalpatti Tea Privately,
and another one, some Roman, na?
and Rahman.
And Raman Properties Private Limited.
No, not private. Rahman is limited now.
They put it.
Oh, they have put it. Yeah, that is interesting. Yes.
He therefore submitted that these properties, which are mentioned in the schedule to the claim, are properties belonging to the company. And without the company, and there cannot be a partition of the said properties. Without a partition of the said companies by the civil court, and the jurisdiction lies under the provision of the Insolvency and Bankruptcy Code. He therefore submitted that the learned trial court failed to take note of the said aspect of the matter. He further submitted that in terms with section 430 of the Companies Act 2013, as the jurisdiction for partition of 430, the Companies Act 2013. He therefore submitted that as the properties in question belong to the companies, and it can only be liquidated by the NCLT by virtue of section 430 of the Companies Act 2013. The trial court did not have the jurisdiction to proceed with the suit. This court is of the opinion that it would not be proper on the part of this court to pass any orders at this stage without hearing the respondents. This court further takes notice that a suit has been pending since 2015, that is almost a decade back. And as such, this court is also not inclined to stay the further proceedings of the suit in the next. Further proceedings of the suit.
Limited item 47.
Last particular, I was asking about whether this matter was second or the second appeal. or not. In the second appeal, I was not the party, only my mother was next party.
So what? See,
Secondly,
what is the second appeal business here?
because against the decree,
Hmm.
the mother has come. And before the second appeal,
Then,
that was also affirmed.
then,
And during the pendency of the second appeal, this father of the petitioner who was not
my specific question was, did you mention that you had a Khatyan at before the trial court?
trial court.
So this was illegal. Any right created after that is 52, hit by
Not
52.
but there is- I have an independent right
No,
by virtue
52.
of it.
It is hit by 52. Okay.
Here is issued an independent right has come. And the civil court's jurisdiction is barred under section 66 of the Assam Temporary Settled Area Tenancy Act.
When the suit, obviously, when there is already a decree passed by the trial court, which has been affirmed by this court till this court, this will obviously prevail. Any intermediary right being created would not be there.
So whatever right is created on that civil court doesn't have any right, There doesn't have any jurisdiction. So this is completely independent proceeding.
So what did you file?
Later on, I filed a suit that was dismissed.
Suit for?
Declaration that execution decree is null and void.
That was dismissed.
Dismissed.
And you let it in finality.
Yes, but when without court doesn't have jurisdiction to pass an order that never attains any without finality. And second thing, what I'm saying,
Court did not have jurisdiction.
yes, that the court doesn't have jurisdiction
Why?
to interfere with the Khatia.
How do you
Because of
say
the-
so? How do you say so? 66 says what? It says that the civil court does not have jurisdiction.
Then
So?
independent right, completely separate proceeding.
This Khatyan was issued subsequently.
Of course,
Then
but they is separate from the.
at the time when the court passed the decree, then there was no Khatyan.
No.
So any creation of rights subsequently in respect to a property which is being held now, which have been already declared by the court, is hit by 52. So that's
It is completely
only good thing I can do for you, seeing your persistent attempts to show something, that fix the matter on 2nd of April when I am not sitting.
anytime I'll be a weekend,
Very good.
because it's independent, completely independent.
You want an eviction by that time, or get a stay order and second by some other court. From me, you don't get any. You ask for any order today, I can dismiss it. You want a dismissal for stamp of authority, or can you control the trial court, executive court till the next stage? Your choice, but you don't have it. Dismissed?
It's completely.
No. What application did you file?
Yes, that application without objection.
Under?
The provision is not given.
Very well. 47?
This may be dictated, actually, he has two blacks, one under 47, another without, because he has an independent right
Hmm.
by virtue of that.
One is what right?
It's independent right because.
What?
Because Satyan was issued in favor of my father.
So?
My father has.
You did not show it. Tomorrow you forget about the Satya. Let's assume that the owner, somebody else, uh, grants you a deed of sale. A sale deed is given. So if a sale deed is being given out there, then in that regard, that sale deed, you have to, after the decree being passed,
And it's a different aspect.
then
Because here got a competent authority. A competent authority has given me something. And on which civil court other than jurisdiction.
the
alone.
civil court's jurisdiction is there. Don't worry. We can very well import that judgment of that full bench. You want to argue on that, we can import that judgment of full bench, where the full bench was taking into their judgment, what is Daulat Ram Lakhani. Don't worry. When anything is being done without jurisdiction out there, then obviously the civil court jurisdiction is there. Don't worry.
Experience. But in this.
You want that to be taken as a ground to defer the matter till second? Very well. Take it. Today we are in live streaming. So therefore, you need a good ground. Take it on the ground of Daulat Ram Lakhani.
Otherwise, I have one Supreme Court. The Supreme Court has said that any order is passed without there being jurisdiction. That is known as.
The trial court definitely had the jurisdiction at that point of time. Then it can never be known as. Can it be known as subsequently? Did you file it? You should have filed under Order 21 in 97 or 47.
Yes, that petition, that objection, I have filed an objection.
Then what happened? What did the trial court
This
do?
objection was not decided at all because that issue was not decided.
What did you, such a long order?
Kindly come to a page below.
Where did you mention that you got a Khatyan
Yes, sir, yes.
in your petition?
Yes.
Where?
In the order itself, it was.
No, forget about that. Let us see your petition.
Yes.
Where is it? Oh, this was earlier
At
dismissed
page
by
25.
me.
At page 25. No, that was another issue. No.
Ah,
That was
This is
another.
the second time.
That,
I think we should dismiss with cost.
no, that issue was completely different.
From 2000, how much time you have taken? My order was in 2024. Almost 1 year. So
That
per
was
month,
regarding stay below.
we give you how much? 10,000 cost? Where is that?
Yes, at page 25. At page 25, para number 5. The objection starts from the
This is a reply.
no final objection. This is.
Now, what is this final objection with that? Where is your petition?
Yes, yes, that is.
Which one?
At page 24 and 11% is at page 25.
24. In continuation of the preliminary objection then pending and the subject to the availability of the court records when against the execution of the report.
Page 25, paragraph 5. They have admitted the fact that yes, Patian was issued.
Civil suit was decreed when?
Below 1994.
You were given a quarter,
My grandfather.
was given a quarter. And and there was a decree for eviction from the quarter.
Yes, sir, for
Eviction of the decree from the quarter. And this is the decree which is sought to be executed. Now, in the meantime, you got the land right over the land.
right. Awarded them.
Where is the right question?
But here is not annexed, but
Then how do you know?
but I have taken,
Because you have not mentioned anything.
yes, they have admitted,
And where is the decree?
they have admitted it.
Where is the decree?
The
Quarter situated at Pool Staff Lane, Naharkotia, North so and so, South so and so, Long John Road, Company Quarter. Range. How do you say that this is the same land on which you got the Khatian?
they have admitted it.
Who?
Page 29, they are replied.
Where?
Paragraph 7. That the environment of paragraph 5 has no
No
relevance.
relevance to the title, the
Title
suit appeal and the
execution,
second appeal. The judgment debtor had no right to let out the bequeathed property to anyone else as the same is owned by the decree holder. The judgment debtor have no right to let out part of the premises. The judgment debtor should okay, rightly so. And what does the trial court say?
Yes, I court did not discuss at all below.
Okay, we don't find any good ground. Here, why you are saying page 71, he has discussed everything.
No, we don't.
Page 70, kindly see. Instead of title revive by from the suit was in wrong by manner, the land of 1 acre so and so.
As executing court discussion starts from middle 79.
What happened on 16-1? 16-1, what happened?
Now read that to the-
You have not produced the Khatian also. Did you give evidence? Did you give evidence? Did you ask for that? You did not file even application. You should have filed an application under Order 21 Rule 97 as a third party. You have not done that.
It was not written, but non-quoting of provisions of law doesn't matter to the court case, my lord.
You should have come up now. I have an independent third party right. That is not your case.
It was taken without, the ground was taken ultimately, and secondly, without where this Khatian was admitted. The portion of without evidence. That too before a executing court because.
No, but unless you claim the Khatian, any Khatian issued subsequently during the year.
I'm having the Khatian. Trying to have a look at it. Khatian.
Absolutely no. Anyway, let me be good enough to some of your lawyer counterparts by issuance of a notice. They may be engaged by Tata Tea.
Yes.
No, but no stay.
That will be considered after their appeal.
Notice making it returnable on. I come back on 5th of May 2021.
Right? No problem.
Okay, issue notice making it on 22nd of April 2025. Steps be taken upon the respondent number 1 and 2, 1, 2, and 3 by registered as well as usual. In addition to that, the petitioner is further directed to effect service upon the respondent numbers 1, 2, and 3 by way of the still routed through the registry of the spot and file an affidavit of service on or before the next stage. The learned counsel, the petitioner hearing have sealed the order dated 12/12/2024, passed by the court of the learned civil judge, Junior Division, Naharpatia, in title execution case number 5 of 2019. The submissions were made by the learned counsel. The case of the petitioners herein, is though a decree was passed on 19/8/1994, but subsequently against the grandmother of the petitioner. Grandmother,
Khatian. Yes, decree was, yes, yes.
grandmother of the petitioner, in title suit number 5 of 1982. But subsequently, and the suit thereupon, and the decree thereupon was confirmed in appeal by this court. But there was a third party right being created in favor of the father of the petitioner by issuance of a rayati khatiyan after the judgment, after the decree passed by the learned trial court. The learned counsel appearing on behalf of the petitioner submitted that the creation of this tenancy right by the state of Assam by issuance of a rayati khatiyan gives a third party interest to the petitioner, to the father of the petitioner as well as the petitioner, to resist the execution of the decree. He therefore submitted that in terms with Order 21, Rule 97 of the Code, he therefore submitted that the objections of filed to the execution of the decree is in terms with section 47 of the Code of Civil Procedure 1908, and consequently, in view of the recent judgment of the Supreme Court in the case of Perumal Dev to Elas versus B. Rajamani and another reported in so and so. This proceeding, or having the question, wherein question of title is being raised, ought to have been decided in terms with Order 21, Rule 97 of the court. The learned counsel submitted that this very aspect of the matter was not at all considered by the learned trial executing court while passing the impugned order. Taking into account this court have also perused the impugned order dated 12/12/2024, passed in title execution case number 5/2019. Taking into account the said submission, it is the opinion of this court that the petitioner have been able to make out some case, a prima facie case for grant of a stay of the execution proceedings, in as much as if the stay is not granted, it would result in causing irretrievable injury to the petitioner. Accordingly, till the next date, this court directs that the execution proceedings number 5/2019 pending before the court of the Civil Judge Junior Division Naharpatia shall remain stayed. But yet, this should be your submission, not all these things what you are saying. Yes, Mr. Raman.
Similar to the earlier case about it.
Huh?
Similar to the earlier case about
Which case?
47.
Which case?
But here in this case, my lord, one
Which order you are referring to?
Lord, the order is at page 56, your lordship.
Considering the matter in its entirety, entails the prayer of the petitioner to call for a status report from the circle officer. Verify the official. Which order you are referring to? Page 52,
Page 56.
50?
56. Inform order.
We have seen the
Order is first on application. 500. Order 21.
What is wrong? Why you are here? You filed what application? Order 21, Rule 97. Then why didn't you file an appeal? What is this type of matter you doing here? Your petition has been dismissed. Then go there, file appeal. There is no required. See, the judgment in that case of Silver Line categorically says that there is no required if you don't make out any case. Here you had asked the circle officer says that you are no longer, you are not in possession of this. Then
My lord, only base. Base.
Mr. Sahu took me 3 days. Then only I passed some order. Now tell me here, you don't have a case.
No such thing.
What right you have over that land? Tell me.
I filed petition. That is at page,
Let us see your petition.
at page 37 onward.
Huh?
Page 37 onwards, your lord.
Page 37. What is your petition? Let us see. Order paid 101.
I've been following the land, measuring 3 bigger to got the tender.
So what right do you have over the land?
By the right of inheritance, I am possessing the land.
Inheritance?
My father was in possession during his
No,
life,
what right do you have? Adverse possession.
my lord. But in the Ikna copy, my lord. my
Huh?
father-
Decree declaring that the third party petitioner has got every right, title and interest. Huh? What right do you have? Mr. Counsel, I think you should go there.
At case 13.
No, you challenge this before the district court. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of.
That is fixed up.
Mr. Counsel, if I go into this, I'll have to dismiss it. So you go there and file your appeal. You don't need time. Should notice and I heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Post. This is a petition filed under Article 227 of the Constitution challenging the order dated 6/2/2025. Passed in means the case number 115/2024, arising out of title execution case number 02/2023. It is a settled principle of law that when a proceedings under Order 21, Rule 97, read with Rule 99, Rule 99 and 100, when in a proceedings, it is a settled principle of law that any order passed in the proceedings under Order 21, Rule 97 would be a decree in terms with Order 21, Rule 101, 102 of the Code, 102, 103, 103 of the 103 of the Code. So taking into account that the order dated 6/2/2023 filed could be a decree, and the petitioner has an avenue to prepare an appeal under the Code of Civil Procedure 1908, this court is not inclined to exercise its supervisory jurisdiction in the instant proceedings. So accordingly, the instant petition stands dismissed. Dismissed, or it was 17 today, 12 to now, 17 to 2020. Instant petition stands closed. However, liberty is given to the petitioner to prepare an appeal against the order dated 17/2/2025 before the first appellate court, and the period from 4/3/2025 till date be excluded while computing the period of limitation. So the petitioner, the counsel for the petitioner is given the liberty to file an appropriate application before the registry of this court for the certified copy of the judgment or orders so include judgment and orders so includes in the instant proceedings, and on such application be filed, the registry shall forthwith provide the said certified copy as well of the judgment and orders so enclosed to the instant proceedings.
Item 49.
Place of the word closely certain.
Dispose I can't. Not entertained. Fantastic. Yes, what is this, Mr. Haq?
I was directed to file the additional affidavit.
Ah,
Have
for
filed
what?
about subsequent dates, about subsequent dates.
What?
About subsequent dates.
Somebody's names,
Subsequent dates, of the trial.
subsequent dates.
Fine.
Five for necessary order. One order, one rule 10(2). This is what it was rejected without making them a party, the state a party. Isn't that the case? Which one?
90 days matter, we could not find the written statement. The
Huh?
date is 90,
You could not file the,
written statement within 90 days.
then you filed it, na?
I filed.
But it was not
Not
accepted.
accepted. That order was not enforced earlier.
Under one or wait, plaintiff has filed it. Plaintiff has filed the petition under 151 fixed for orders. So this is for orders. So then you have approached this court also.
Page 23.
Today is what date? 11, 10. Where are the respondents? One respondent. You can serve it with through the state. The notice making it returnable on 26th of March 2025. Steps be taken upon the respondent by way of registered during the course of the day. In addition to that, the petition is also directed to take steps by the state, routed through the registry of this court and file an affidavit of service on the next state. The case of the petitioner hearing is that the petitioner had been debarred from filing the written statement in view of the fact that the period of 90 days had expired by an order dated 5/10/2024. This order has been put to challenge. It is the further case of the petitioner that an application was filed under section 151 before the learned trial court. For recalling the order dated 5/10/2024. However, the next date is fixed on 2/4/2024. Taking into account the above, this court would take up the instant proceedings on the next date upon the appearance of the respondent. 25,000, huh? Yes. We will allow.
For admission, item 5, partner.
Anything done?
We received the compensation part of it. Part of the compensation has been received.
So nothing remains now.
There's the balance
should-
remaining.
After you got one
Balance
rupee
has
also it is done.
In fact, they've gone, like the deputy commissioner, they've gone today to the office of the deputy commissioner today to complete the formalities for the release of the balance amount. So by the
So
end.
nothing remains. Taking into account, this court have heard Mr. A. Sandil, the learned counsel appearing on behalf of the petitioner, Mr. R. Bhattacharya, the learned counsel appearing on behalf of the Revenue Department of the Government of Assam, Mr. B. Gugoi, who appears on behalf of the Finance and Health, as well as the Finance Department of the Health, as well as the Finance Department of the Government of Assam, and Mr. T. R. Gugoi, who appears for the District Administration of Swans. This is taking into account that the state have, taking into account the submission of Mr. B. Gugoi, that the entire amount has already been placed before the Deputy Commissioner. And the submission made by Mr. R. Bhattacharya, the learned counsel, stating that the said amount would be released upon when the petitioner files appropriate application. And Mr. S. Sandil, the learned counsel for the petitioner, who submits that due application have also been filed. This court would not like to further continue with the instant proceedings. This court, however, observes that the authorities concerned shall make due payment to the petitioners, if not already paid, within
Within this month itself, by 31st of
within the month, on or before 31st of March 2025. Proceedings accordingly stands.
in fact, they went on some occasions, but the petitioners were out of station. Today they are going to the district office. I'm so grateful.
Obliged.
Admission item 6,
What is this? What are you challenging?
By order 9 rule 13 petition by dismissal. Against that appeal was preferred, appeal also dismissed. It's on the ground of delay. The trial court is ordered is at 67. Appellate court is at 7.
So the first part, if it is not true, the second part can't be. But the first part, you did not adduce evidence.
Wait.
Why?
My
Because your case is somebody else filed a written statement on your behalf and you wanted to prove it that. But you were given opportunity, you did not do anything.
case is that no opportunity was provided.
No, opportunity was given to you, your counsel was absent. 1 lakh cost. I think we will allow it, the cost of 1 lakh. Opportunity to, not setting aside, opportunity to adduce evidence. You failed to do.
Take up tomorrow, my lord, I will take the instruction whether they can pay the cost.
Because without cost, this cannot. It will show a very wrong picture. If we don't impose a cost. There was lapses on the part of your counsel. Have you taken any steps against that counsel? No. Then how can you raise these pleas? I can be very considerate enough and say that, okay, with a lakh cost, they may be. What is the land for?
But this is a cooperative society, my lord. There are about total 400 bighas of land allocated to society. Then, my lord, there are some other shareholders that taken apart, my lord. Then that this land, this is about 120 bigha, my lord. That is to the society and the members. There are
Where?
At Sipajhar. The suit is for declaration of possessory rights. It is all agricultural land.
Possessors of the land and in the suit and for declaration and protection of their rights as possessors on the suit land and injunction. So on your behalf, somebody else filed a written statement. But you have to prove that, no?
That evidence,
Because the evidence otherwise here is clear. You were given the opportunity.
it's only the record of appeal.
Don't want to see that. There's a stay. No stay. Nothing.
These persons are in possession of the land.
Huh?
But the petitioners are in possession of the land.
You are in possession of the land. But the suit is not for eviction.
Only for declaration of possessory rights and also a declaration that there is one judgment in the criminal division that these the petitioners are in possession of the suit land under section 145 CRPC. That is not binding on the plaintiffs. That declaration is not.
Claiming the plaintiffs are in possession of the suit land and further a decree be passed declaring the possessory right of the land. You have a patta.
But this is TV taught by the violated by the government to the society.
Chalo. We take it about 2 o'clock tomorrow. Take the amount. That is the only thing in this book. Cost of a lakh. It's the matter tomorrow at 2 p.m.
Item 7.
What are you challenging?
Lordship, the respondents had a plaintiff.
Which order are you challenging, Mr. Shom?
Pays start to 121 euros. Long order euros.
Yes, but why are you challenging this order?
Lordship, two petitions were filed by the plaintiffs here. And one praying for adducing secondary evidence and another praying for direction to the defendants, the present petitioner, to produce the documents. Both the petitions were simultaneously allowed. And those documents, whatever documents they have sought for, out of some, only some documents were in the possession of petitioners as per their petition and their argument. When other documents were in the possession of defendant number IOC and another two persons, not in possession of the defendant 1.3 present petitioners. So, Your Lordship, I do not have the documents to produce produce before the court, Your Lordship. That was not considered, that those documents are in possession of the plaintiff's petitioners. Your Lordship.
Your replies were
My reply, Lordship. 111, Your Lordship. Against petition under section 165.
who is Pranay Basumotari?
Pranay Basumotari, husband of the petitioner number 1.
He is not a party to the suit.
Since this is died, he has already died, expired.
So you deny that these documents were in your present possession. Who is Hitesh Oza and Pratibha Baglari? They are defendants.
They are not defendants. They are part, staff of earlier staff. They are not made party to the suit.
Did they mention about these documents in the claim?
Plain, Your Lordship, yes, page 26, it starts. In the plain, they have specifically pleaded that which document in whose possession, Your Lordship. It starts from page 26.
Okay, but now where do they say that all these documents are in your possession? Are they in their possession? You say that all these documents are in your possession?
Your Lordship, I have, the petitioners have denied, Your Lordship, that
11U, page 35. Is a suit for what?
suit for suit for declaration, rendition of accounts, and or appointment of receiver and permanent injunction. And prayer, Your Lordship, Your Lordship, fine. Page 42.
Now these kindly come to page 126,
Lordship.
document number 11P. These are documents which must be in your presence if you are.
In respect of the agency, Your Lordship. Those documents,
Those documents which you are in possession,
yes.
the land in which LPG godown was constructed and was purchased by the plaintiff, the unregistered sale deed executed by Binoy Doimeri in favor of the plaintiff for sale of air. Is that document with you?
No, plaintiff, it must be in the possession of plaintiff or either Binoy Doimari. Binoy Doimari was made party. Performer defendant number 5. Page 18.
So when these letters, some letters are being sent by Pranoy Basumotari to somebody else, then how the original will be there with Pranoy Basumotari? The council?
The original actually what is signed. Some of the we have repeatedly said about the
Let us come to the question of 11A, page 122. This is a document where the plaintiff and the Pranoy as partner of A1 appointed some person. The original agreement was given to Hitesh Oza and Pratibha Baglari. The Xerox copy is Iman. So if the original is with somebody else,
who is out of reach, Your Lordship, as regard Hitesh Oza and Pratibha Niswar.
then how can you say that these are documents available with the plaintiff and the defendant?
Your Lordship, they were staff. So ultimately the control were with them, Your Lordship. Now since as a whole, since it was
No. Civil procedure does not work in that manner. Then you have to issue summons. Order 16, Rule 6. Issue summons. You can't get him, you have to get him under order 16 in 1. And get summons be issued for the production of this document. This is how you have to do it. You are asking him to produce. This is the power being exercised in terms with order 11/14. If he doesn't have the document, he cannot produce that document. Now come to 11B. Pranay Basumati as partner wrote a letter to the plaintiff regarding information of ER. This document is marked as Annexure 2. This letter is written to you, plaintiff. Then it is with you.
But we have said that one, we have stated that few documents which are prepared by mechanical process, which are also available to us. So let us, we have said that the movement consider.
There are two aspects. One is for direction for production in terms of section 66. You are asking that they should be directed to produce. The question is, why you could not produce it? Where is your explanation to that? Why do you want to? Just for example, the document at 11B. Trial court have not looked into all these aspects. 11A, you have to take action in terms with that law. 11C, Pranay wrote a letter to the plaintiff. This is again a document to you. You want a office copy? SD. You want that? You have to therefore say that these documents, you have had it, you lost it. Then only you may be permitted, but this is not your case in your application. Isn't it?
Your lost in our application, we have stated that few of the communication as photostat copy which contains the original signature of the Pranay document. So that may be considered. Since if they can't produce it, that may be considered as original.
No, if the signature, a photocopy which is there, which has the original signature, the court can accept it. But it will be subject to appreciation. They may put it under objection. But for that, the courts cannot allow a photocopy out here, which the court allowed it. What did the court say allow? See? After transferring the license in her name, the defendant along with her kicked out the plaintiff from the business area which was specifically shown in so and so. Original documents shown in 11T and other documents shown in 11M and AR presently under the power of Iman. Now you have 11T with you. 11O and 11B are you with you.
11 people.
Yes, 11 Lordship.
So you produce those documents before the court. These documents you produce it.
Lordship.
11T, 11O and 11B.
Only these documents. Your Lordship.
Now 11T, 11M, 11O and 11B you produce it.
Yes, Your Lordship.
And these documents which have some signed copy. You have to do it. You know it that these documents are not there. If the court permits you, the court cannot allow merely to allow you secondary evidence unless you fulfill the task in terms with that. This court did not look into those aspects.
Your Lordship comes to page 134, Your Lordship.
Ah,
After 11 as Your Lordship.
Yes.
These documents can be treated as original. So we have said that these documents, Your Lordship.
so these documents may be treated as containing the original signature. Yes. But on the last day, if they have the original signature, that will be dependent. You can produce it as evidence. The court may put it, allow it, subject to your objection and appreciate it, how it is to be done. heard Mr. A.R. Sohn, the learned counsel appearing on behalf of the petitioners, and Mr. B. Pusila, the learned counsel appearing on behalf of the respondents. Respondent, na? Yes. The instant petition has been filed. You are appealing for whom? Who is you? Who is to? You have some documents with you?
Many documents with them, Your Lordship.
Anyway, let us not go into those aspects. Let us keep that aspect alive. This is a petition challenging an order dated 26/7/2011, passed in title suit number 02 of the 2017 by the court of the, what is the name of the court? Court of the Civil Judge Udalguri, in title suit by the court of the Civil Judge Udalguri. It is seen that the learned trial court by their order disposed of two applications. First is an application filed by the plaintiff, who is the respondent number one herein. Respondent number one. Respondent number one herein. Whereby the plaintiff sought for a direction upon the defendant to produce some of the document, to produce the various documents mentioned in the said petition, being petition number 606. It is further seen that by the said impugn order, another petition being petition number 607/21, dated 30/7/2019, was also disposed of. It is relevant to take note of that while petition number 606/2021, dated 30/7/2019, is a petition directing the defendant numbers 1, 2, and 3 to produce certain documents. Produce the documents mentioned in the said petition. The petition number 607/2021, dated 30/7/2019, is a petition thereby to permit the petitioner, the plaintiff, to adduce secondary evidence. This court, during the course of the hearing, inquired with Mr. A.R. Sohn as to which are the documents which are presently in his possession. The learned counsel submits that the documents which have been specifically mentioned in (11P), 11M, 11O, and 11V are in his possession. He, however, submits that the other documents are not available. The originals of the other documents, he submits that the defendant numbers, the petitioner, who are the defendant numbers 1, 2, and 3, is not in possession of the other documents. Mr. B. Pusila, the learned counsel appearing on behalf of the respondent, respondent number 1, who is the plaintiff by the submitted, that the documents numbers 11B, 11C, 11D, 11E, 11F, 11G, 11H, 11I, 11J, 11L, 11N, 11P, 11Q, 11R, and 11S, though are photocopies of the document, but contains the original signature of Pranay Bosumotari, brackets since deceased. Taking into account the above submissions so made and as it is relevant and it is taking into account the above submissions made by the learned counsel appearing on behalf of the parties, this court is of the opinion that the impugned order dated 26/7/2021 passed by the learned civil judge Budalguri in title suit number 02 of the 2017 requires certain modifications. Accordingly, requires certain modifications inasmuch as the said orders have been passed without taking into consideration that in respect to some of the documents, the petitioners have not taken steps as is otherwise envisaged under law. Even otherwise also, it is relevant to take note of that when there was a petition being filed, taking direction upon the defendant numbers 1, 2, and 3 to produce certain documents without disposal of the said petition, the learned trial court could not have directed the adducing of secondary evidence in terms with Section 65 of the Indian Evidence Act 1872. Taking into account the above, this court disposes of the instant petition with the following observations and directions. The defendant numbers 1, 2, and 3 who are in power, who is in power, who has the power, who is in power and possession of the documents mentioned in 11P, 11O, 11N, 11O, and 11V are directed to place the documents are directed to produce these documents before the learned trial court on the next date so fixed. As regards the documents referred to herein above, wherein the plaintiff contends that these documents contain the original signature of Sri Pranay Basumati, it is the opinion of this court that the said documents be admitted into evidence, however, subject to such objections which may be raised by the defendant in the suit. The objections, it is the further opinion of this court that these objections be dealt with at the time of appreciation of the evidence while the suit is taken up for judgment is decided by the learned trial court. This court further takes note of that the further proceedings of title suit number 02/2017 was stayed by an order dated 5/10/2021. So taking into account that all the parties in the suit are duly represented before this court, they are therefore directed to appear before the learned trial court on 9/4/2025. It is observed that on the same date, the petitioners herein, who are the defendant numbers 1, 2, and 3, shall produce the documents marked documents being document numbers 11P, document 11P, 11M, 11O, and 11V. On production of such document, the learned trial court shall pass appropriate orders in respect to the same documents, and thereupon proceed with the disposal of the suit in accordance. Okay.
Item 8.
Yes, what are you challenging?
Page 45. petitioner is a degree holder.
What is the execution sought for?
For delivery of first position.
Decree on 24/9/2004.
Four.
Appeal.
Appeal, my lord, title appeal 3/2005. It was dismissed on 9/12/2015.
Second appeal.
Against that, no second appeal.
So 2005 it ends.
Yes.
Yes.
And the application was filed in
Initially, application filed, my lord, in 2004. That execution, but when civil revision was filed for this honorable court, and whole record was, my lord, transmitted to this court. For 3 years, it was remained here. So title execution was remained, my lord, stay to proceed. And that period was not counted. And section 15(1) was not considered. That is.
now what happened to that execution petition?
Execution, no, it was, my lord, dismissed for default. In 2012,
And you did not take any steps.
fresh execution petition was filed. And so after filing this application, my lord, the court held that style.
What is wrong?
My lord, your lordship, and this is annexed to, by this order, my lord, record was gone from the execution. And it was sent to the, my lord,
Understood. Everything is understood. But at the end of the day, the first execution application was dismissed for default. If it was execution was dismissed for default, you appeared in 2011 and thereafter you stopped appearing. So it was dismissed for default, it has come to an end unless you would have continued by seeking restoration, which you did not. So that has gone. But there is no bar for filing subsequent execution application. That is also the law. But if you file, the earlier one has become a nullity, non-est. Whatever maybe it has been done nothing is remains, so that you are on to the second execution application. With the second execution application having been filed in 2018, what remains?
my lord, whether that period, that is, in High Court, the record was, I was restrained, my lord, that period will be well counted in the.
But it
excluded.
was in that proceedings.
Maybe, my lord, that is why, my lord, I have a judgment of this info.
Huh.
Here also, my lord, title execution was dismissed, and thereafter it was filed. That period was also counted. My lord, paragraph 3, 4. Your lordship.
So you mean to say, as per the judgment, the total period is 12 years. You may file how many applications it is there or not. But the fact that if during this 12 years period, any portion has been stayed, that area period has to be excluded. That is, this is what the Supreme Court says.
Lord, that Anandilal case was considered in a subsequent judgment by Lord, and 2001 Supreme Court 279. That year 2001.
Here a bit the facts is different. This is not the issue involved here. Here the issue was decree passed in 1970, first appeal was in 1973. Execution petition was filed only in 1998, after 15 years. That was, and Anandilal judgment was taken only on the context of that hardship cannot be a basis for condoning the deed. There's no quarrel with that. What is the proposition laid down in Anandilal judgment is on the question that a person has a period of 12 years for the purpose of executing his. If in the meantime, for certain period, there is a stay, this period is to be excluded. That is the proposition which is being given.
My lord, the report shows that starting from the year 2004, till the filing of the appeal disposal thereof, and even after the civil division filed by them, at no point of time there was any stay of the decree. And decree was continuing.
There was any
stay.
stay.
No, the record was false. They also kindly see the order of the record.
That record might have been called in their CRP 218, my lord, because we did not prepare any appeal. So against in the execution proceeding, when an order on 17/8/2008 was passed, they preferred a revision, my lord, for the honorable. But
Give me the date, just give me the dates.
my lord, please,
Trial court's judgment,
my lord, trial court judgment 24/9/2004, my lord.
24/9/2004.
Yes, my lord.
Then appeal,
Decree was executed, execution case number 29/2004. My lord, it was filed in the year 2004 itself.
execution case.
Yes, madam. That was execution case number 29/2004.
Okay. Then
Then there was an order passed on 17/8/2018, my lord.
17,
17th of August 2008, my lord.
17th of August,
Yes, madam.
2008. Appeal was dismissed.
No, no, no. My lord, there was no appeal. In the execution proceeding itself, an order was passed, and against that execution proceeding, they preferred a revision for the honorable body.
Okay. There was no stay.
There was no. That was CRP number 218 of 2008.
CRP number
18, my lord, 218.
of 2008.
Eight.
Then
There was a direction in that, my lord, dated 25/8/2011. There was a direction to them. That direction is already there, my lord, at page number 45.
no, okay. So they filed this in 2004 within there.
Yes.
Then they allowed it to be dismissed in 2012.
12 on 27/9/2012. It was dismissed.
9/2012. And then they filed the next one in 2018. So there was no stay,
There was,
thereby arresting the period of limitation. Limitation exists.
during that, my lord, 15 months.
Your lordship kindly see the annexure two. By this. Page 21.
In the order passed in so and so, accordingly send down the case report to the honorable court as directed. But this is not a case of stay.
But that period we could not kind of proceed with the execution. case.
No. That is not the question of you could not proceed. You did it at your cost. You came before the court.
That's correct, but this
You never asked for stay of the execution. The court called for it.
records.
Then-
Record was sent by the learned Munship, my lord, to the
Yeah.
court. That period will be counted and that period will be excluded under. section 51 of the Constitution.
So 15(1) only refers to the institution or execution of which have been stayed by way of injunction or order.
For order. For order.
Or order. The time of continuation of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded. This will be excluded.
My contention is that when at that period, the execution proceeding was not in operation by, because the record was not there. At the execution by the proceeding is there, then manner I have no case. The record was sent to the honorable court, and in 2006 it was returned back. So that period will be counted for the excluded order. That is the issue. Because it is also ordered by this trial court, and that is case 21. It's not that, my lord, we have sent or the course order.
Where is the revisional order?
Revisional order page 25.
And when was the record returned?
That is Annexure 6, my lord,
Huh?
page 32.
First appellate court judgment is one.
It's 24/9/2010.
24. Arey, first appellate court judgment.
9/12.
9/12. You filed it on 26, 2018. Then, even assuming you get the time, then what happens?
That one, it will be less than 12 years. Years, 1 month, 1 day will be excluded.
Hmm?
If that period is counted, that 3 years, 1 month, 1 day will be excluded.
What is the decree for?
Right title enter recovery of polish.
Huh?
Recovery of polish.
Right title interest,
Right.
partition. What is the decree? Evicting the defendant. Record was sent back when?
Annexure 6, madam, is 32.
27, 8, 2008. And was received back on
Is received back on 26/9/2011.
fifteen nine. 15/9, 2011. So the question involved is as to whether this court can interpret that calling for the records by the trial court, by this court, would come within the ambit of stay of the execution proceedings, and that too at your behest. You filed.
Civil division, we
You delayed the proceedings. You delayed it.
I,
But then why did you allow it to be dismissed? You were not interested. So why should we allow? I think it is a high time.
that period will be
Close.
counted or not, at least. That would period will be counted or.
No, I don't think you better go to Supreme Court. This type of,
Your worship,
if you are not interested with these proceedings, you should. I think some lesson has to be learned.
94 judgment also reflects on something. That it is restrained by some way, any other way.
84 judgment. 84 judgment is not for that. 84 judgment only says that there was a stay.
There's a partial stay that was questioned.
No, there was a partial stay of that you could not. So that, see, what it was being meant out here is that you are given 12 years to execute.
Here it is also a stable restraint. Restraint means restraint from execution. That is also reflected in this. We are restrained because the record was not there. Because if you have not-
You have come before the court
it is correct, but that
only on the basis that there was some survey being asked for.
at the records is there, my lord, then my lord, I have, record was not. Record was at that point of time.
You should have challenged it.
I cannot challenge that order. And then
We'll do one thing. Fix this matter again on, having heard the legal counsels for the parties, fix this matter again on. Okay. 13th March at 2 p.m. Dispose it of. I am not in favor of you,
but
but
can
then
it be
also.
on 17? Can it be on 17? 17. 13.
18th March at 2 p.m. Nothing you have to do. Will take some time to. It was allowed.
For rejection of the, because we had invoked surfacing jurisdiction, madam. Way was pending, and then madam, this suit filed by the plaintiff, in that we filed this application under order 7 for rejection of the plaintiff. Saying that it's a special area, madam, the special law will prevail over the general law.
It was rejected.
They filed objection, my lord, and thereafter that was rejected, then we came here. Our ground is, my lord, clever drafting, my lord.
But doctrine,
Clever drafting. My lord. In the petition, my lord, at page 205 is the impugn order.
there is a trial court judgment.
Trial court judgment, my lord. The annexure 11, my lord, page 205.
Page
205. Dated 15/11/20.
Here's me the data, what is the fraud?
No, the fraud is apparent. The fraud is apparent. What had happened here? We obtained the term loan from the Central Bank of India. Now we had two parcels of land, Schedule A comprising of 2 kota 10 lechas, Schedule B comprising of 1 kota. This 2 kota 10 lechas was mortgaged to Central Bank of India. There was a loan of around 7 lakhs. Now thereafter, we approached the UCO Bank, say that we wanted more finance in respect of the project, and we disclosed to them that the property is already, there's already a loan by the Central Bank of India. Now, Central Bank of India then transferred the title deeds to the UCO Bank. And UCO Bank accordingly
2 kota 10 lakhs.
of 2 kota 10 lakhs, and UCO Bank accordingly sanctioned an amount of 22 lakhs. So the earlier deposit of title deeds which was given to Central Bank was taken over by UCO Bank. Thereafter, we are residing there, and all of a sudden we receive a notice from the bank official. And we come to know that this particular property is shown to be mortgaged against a loan availed by the defendant number 5, which is a company, against a whopping 23 crores of a CC limit.
Which property?
2 kota 10 lakhs.
You
by
had
the same bank.
You had nothing to do with it.
I disputed. I disputed. Now, I said that I was made to sign on a dotted line where I had mortgaged it in respect of my loan of 22 lakhs. And this particular property is shown to be collaterally securing another cash credit availed by the defendant number 5. Interestingly, my lord,
And how is defendant number 5 connected with this?
defendant 5 was my distant relative, and he also happens to be a guarantor against my loan. In fact, I have pleadings to the effect that it's defendant number 5, it's the handiwork of defendant number 5. Defendant number 5 introduced me to the bank official. He said, I'll procure a larger loan for you, and you therefore transfer the existing mortgage from Central Bank of India to UCO Bank. Now, thereafter, UCO Bank says that this particular property, which is already encumbered against my loan, is shown to be a collateral security for a cash credit by defendant number 5. Now, interestingly, my lord, the bank claims that this particular mortgage was created by deposit of title deeds in the year 2013. 2009, I'm sorry. Now, the question is, if the title deeds were already deposited against my loan in 2007, where does the question of me again submitting title deeds in 2013 arise? That's number one. Secondly, my lord, in 2013, when they show this property being mortgaged for the CC of Lohit Construction, my lord, they include a non-encumbrance certificate along with the document. However, they themselves know that it is encumbered again with them only as against my loan. Lastly, my lord, what they now try to say is that it is not just the land, a building, G+2 RCC building is also encumbered along with the land. Now, the holding number that they've shown is that of the building standing on my contiguous plot of land, which is scheduled. I'll just show the
Which
document,
you have not encumbered.
which I have not encumbered for either of the loans.
Schedule B.
Schedule. And I say this G+3 building is actually there in Schedule B, is not even there in Schedule. In fact, two documents, if I may just show, if your lordship may have page 90.
Where is your allegations in the claim?
Para 25 onward of the claim. Page 21. Well, sadly, I cannot rely on the written statement. On a perusal of the written statement, it will be fortified that there is a clear fraud. Because in the written statement filed in the suit, they say that my term loan had become an NPA. And therefore, they called me and and thereafter it was, this same property was encumbered against the CC of Lohit Construction. Now, the question is, if it is already declared as NPA, why are you taking a stressed asset and using it for securing another loan of nearly 23 crores? I'll just show my lord. Page 21, if the lordship has.
Where is your allegation?
It's
What you are saying?
25 onwards, my lord. 26.
Paragraph 25.
Paragraph 25 at page 21. That's how the bank officials came. And then at paragraph 26 on the following page. I may read.
Now, where you are saying only this, how it's went from central bank to,
Oh, that is clear from the documents, my lord.
no.
From the pleadings, your lordship will have paragraph 16 onwards. Paragraph 13, the initial mortgage with the central bank, and thereafter paragraph 16.
Now here you become a guarantor
Here I'm shown as a guarantee.
in OA. Three.
OA 13.
Three.
Three of them.
And what has happened? There is already a certificate issued. OA 3,
OA 3, my lord, yes.
12 crores.
OA 3, no, my lord. Then they resorted to surface again.
No,
Well,
paragraph 28.
Well, there is a mix up of facts. This
The
OA 3,
Eco
my
Bank had filed the OA.
Yes,
for
yes. OA 3, my lord,
Okay.
certificate of 12 crore.
Lohit Constructions, my lord, that is already compromised, my lord.
That's even more disturbing.
That is already compromised.
Now you are enjoying an injunction.
That's what I-
Status quo, yes.
Mr. Gufrani, how is it that the court will decide whether it's a case of fraud or not? With such serious allegations of fraud, how can it be decided?
The issue is this, my lord, there are two plots of land, contiguous. My lord, our loan was given to them on the basis of that 2 Katha 10 lecture. The first agreement, my lord. That is. I'll come to that. They are trying to mix up the other one. That is not our case, Malu. We are not making any claim on the basis of that 1 Katha of the total area of 2 Katha, that second plot of land. This is not the bank's case. The bank had offered the loan, my lord. Even after the transfer or before that also from central bank to Eco Bank on the basis of 2 Katha 10 lecture to them. Now, they are saying that this Mukul Deka, who is their own man, different number 5, Mukul Deka is their own man. He, along in complicity with some bank staff, has extended the agreement to the other land, this 1 Katha out of 10 Katha. We are not claiming that. We
You are
have
now
issued the
taking
notice.
surfacing action only in 2 Katha 10 lecture.
Yes, but
So now the question is out here. He makes certain allegations to the effect that there was no creation of any mortgage in respect to 2 Katha 10
he
lecture.
has admitted
from-
the signature and no FIR is filed till date, my lord. If there is a fraud, my lord, he has been illegally sought to be, my lord, penalized for someone else, my lord.
Well, no, whether he files or not, we are to therefore see as to whether from the reading of the plaint,
Yes, honestly,
from a reading of the plaint, the suit is barred.
exactly.
A bar will operate in terms with section 18, there is no quarrel with that proposition. But if there is no creation of any interest, then it is outside the scope of the Surface Act.
My lord.
Now, they specifically allege that we have never created an interest.
But they have not denied their signature, my lord. He said that
They categorically say that we have never created any interest. Isn't it your case?
Yes, that's wrong.
That we have not created any interest
Because we have
in respect to AI insofar as that person concerned as regards 23 crores, our specific cases, some amount of 8 lakhs 9,000 amount was there, which was pending to be paid to UCO Bank, Central Bank. And you have granted a 22 lakhs, of which 13 lakhs something was given to him and 8 lakhs was paid to Central Bank. And this is what everything has happened. We have nothing to do with any creation of anything wherein the defendant number 5 only stood as a guarantor to them. This is their specific case in their plaint. So the whether from these facts, can you say that there is a bar under the bar would operate? We are not concerned, yes or no. I mean, we are not concerned whether they have rightly said or not. I'm not. But we are to take these developments sacrosanct for the purpose of
what is
deciding and
what is
order
comment?
7 units.
they are pleadings, my lord.
That is the big problem.
My lord. Your lordship will kindly come to our application.
No, your application I can't do.
the statements that we have made.
No. That is also not.
On the basis of the pleadings in the.
No, absolutely. I am not going to look on them. I am only going to look into the question of the plane from the plane. You may have a, Mr. Gusam, you may have a fantastic case.
Madam.
They may be a absolute, in fact, they must have fraudulently in collusion with the defendant number 5 may have filed the two. But can you say, from a perusal of the plane, reading of the averments, that it is, it's a bar?
Barring is this because what they have alleged, they have filed a suit for fraud, alleging fraud. Now, this fraud is not committed. If at all it was committed by them, and that is what is the pleadings there. Pleadings is we have never, my lord, taken given them the loan of the amount on the basis of that second plot money.
No, no. They are saying about the first also.
No, but
First, there are specific cases that
look
well,
at that.
we have only
In
taken
our case,
22 lakhs.
Look at the 10 lakhs.
They are saying against this 2 katha 10 lakhs, you have only given them 22 lakhs. And against that, they have got 13 lakhs, 8 lakhs you have paid to the central bank. We have nothing to do with creation of any liability on behalf of Mukul Deka. This is their specific case.
Your lordship kindly grant me one
Please.
minute. Actually, madam.
Yes, Mr. Goswami, what do you have to say?
The 7.5 lakhs was sanctioned by the central bank. Then that loan was taken over by the UCO bank.
That is, I'm also, he is not denying that.
Ah.
He says that 7.5 lakhs was sanctioned against these 2 katha 10 lakhs of land. Out of these 2 katha 10 lakhs of land which is there,
Yes.
you took over and you said that, okay, I'm going to give you 22 lakhs, of which 8 lakhs 9,000 was paid to central bank and remaining 13 lakhs 40,000 was given. Even. Now, is your surface action is in respect to this 13 lakhs 40,000 or is it something else?
It is the entire amount because
No, Mr. Goswami, my question is very simple. Is your 13 lakhs 40,000, is your action on the surface against 13 lakhs 40,000?
no, it will go against the entire outstanding amount.
Understood. Whatever may be, against, is it only against 22 lakhs? Nothing more.
Nothing. It is against 22 lakhs.
There are basic cases on 22 lakhs.
Then, my lord, my prayers can be that recording that admission, my prayer, specific prayer is schedule A, there is no mortgage insofar as 23 crores. That is my case.
Listen,
I am the plaintiff, my lord. I have sought for the decree, my lord. We'll have page 40 for a moment, my prayer.
here schedule A is 2 kota 10 lakhs. It is mortgage with the UCO bank. Earlier it was mortgage with the central bank. Now it is mortgage with the UCO bank.
Huh?
And schedule B is the.
No.
We are not.
No, Mr. Goswami, kindly. You say that it is 22 lakhs? 22 lakhs? You are agreeable with this 22 lakhs?
Already, it's my mortgage.
No, so we do want. Let them, I can't touch this. You have made that submission.
Yes.
So I will record it and on the basis of that, I'll dismiss your petition, you file an application and he will pick it up and the decree can be granted on that.
We have nothing to do with the schedule B land. What kotha-
No, I'm not on schedule B. Is it more than? Let us see your surface notice. Where's the surface notice? Where's the surface notice? 13.4 notice, 13.2.
13.2 notice, my lord, is at page 180. This is in respect of my loan. Now, my lord, will have.
Wait. No. We are concerned with 18.
We are
18.
concerned with that judgment in that OALs, where they've included my property.
No,
as a-
where is the surface notice? I received your reply on email and by denying your statements and the.
Page 95,
The undersigned
your
will
lordship.
proceed with the demand notice dated 22. Then the case, 23 lakhs we have with interest calculated. Now let us see your surfacing notice. Notice,
My
this is under so and so.
Recovery
Yeah,
certificate.
so-
is-
You see, he's only asking this 22 lakhs.
But that OA is is against my property. That OA which they had filed against Rohit Construction, they have included my property as against 23 crores. my lord.
Which one?
My lord will have page 73, my lord.
Now kindly come to 183.
183, my lord, they're saying I have defaulted in that term loan also. That's another chapter. I'm not concerned.
We are only concerned is your suit on, in respect to this.
Not this, not this. My prayer is, my loan, if I default, let them go ahead, my lord. There's no difficulty. But in the OA, my lord, which your lordship finds at page 73, my lord. They
And,
have-
and Mr. Goswami, you want to take
I'm
over
against
in no, you want to take over in terms with Annexer 6, page 180.
Annexure 3.
Lord, this I'm not even challenging it. I'm showing
no
this,
challenge.
that there is an admitted loan of 22 lakhs against.
188.
Huh?
It is 13 to notice.
Ah.
This is against the 22.
This is against the 20.
And is there any other notice?
No,
Page
but
85.
whatever they have said, it has been compromised in 2018.
So you are only against this?
Only against this,
Then my prayer can,
only against this.
my prayer can be decreased then.
No, we look, that it is limited on this. No, your prayer cannot be declared.
Well, why?
Absolutely no, that has nothing, that is no cause of action. We
Well,
go on the basis
It
that
is
they
not
doesn't
that.
disclose the
My
cause
lord
of
will say
action.
page 85. My lord will say page 85. My lord will say page 85 for me.
What is 85?
Page 85 is part of page 73, my lord. Now, this is the cause of action, my lord. Page 73, if your lordship takes up.
What is this document?
This is the OA that was filed against defendant 5. Your lordship will allow me to show those documents
This is filed.
against Fluid Construction and against me as defendant number
Now
12.
this has been compromised.
It has been compromised 2018.
Then my prayer can be allowed for that.
Why?
Because your lordship.
No,
will
your
allow-
prayer cannot be allowed unnecessarily. Where is the question of fraud?
I will
They
show
are
you-
initiating, no, Mr. Deka, they are, no, Mr. Deka, they are only
clear
initiating.
fraud, my lord.
They are, you have unnecessarily taken up. You are only initiating
No.
action under 23, in terms with 23/12/2019.
My lord will have page 67.
Not necessary.
My lord, it's a clear case of fraud. I will submit otherwise.
Supreme Court,
My lord will
urged
allow me to page
Mr.
the document.
P.C. Gustami, the learned counsel appearing on behalf of the petition. Mr. B.D. Deka appears on behalf of the respondent. Numbers, respondent numbers.
My lord will have the W. One minute.
I won't look into all this.
My lord will have page 87.
I will make it clear that this is only in respect to this.
My lord, there are outstanding certificates where my.
I am only concerned with this, and he says that. In view of what he says, that he is only going to take an action, therefore I am closing it.
Fraudulent mortgage, my lord.
There's no mortgage.
I'm
This is
sure,
this
my
is the
lord.
mortgage.
No, my lord, page.
No, you
10,
have created the mortgage of 2 kata 10 lectures.
Page 89, if your lordship sees.
No.
89 and 90. For a moment. 89, if your lordship sees, my lord.
Mm.
Is your lordship having a page 89, my lord?
Yes.
Page 89, my lord, it says that I confirm that so and so, this is schedule A.
Mm.
An equitable mortgage has been created in respect of 23 crores. Then your lordship will see the documents. Then your lordship will see the documents. Original sale deed was shown to be submitted in 2009, whereas that sale deed has been in their custody since 2007. Document number 4 at the foot of that
This
document.
is Prafulla Deka, your signature.
Yes, my lord. And this property is already mortgaged. In fact, if your lordship sees the written statement, your lordship will be shocked. Form C again, if your lordship sees.
After we record this, his submission that he is only claiming UCO has no claim, UCO Bank has no claim except this 23 lakh.
That you have to record, and the mortgage paid, because this is part of the recovery certificate.
No, we record it on his submission that it is only in
And
respect to
One-
this.
one second.
No, Mr. Dekar, there is no point going into unnecessary. It does not disclose the cause of action we go, taking into account that this action which he is saying is only in respect to this, and
I-
they have no further claims against the respondents apart from this which have been mentioned in
in my term, against mine, apart from my.
23/12/2019, page 180.
100. And form C and D also, your lordship can write it out.
Absolutely no, this is not my business.
Because I filed this suit on the form C and D remains outstanding. And the form C and D will remain outstanding. So therefore, your lordship will record that insofar as if your lordship is taking their statement at face value, your lordship.
Mr. Goswami, you are sure with only 23/12?
Yes.
This
Yes.
page 180
Yes.
and nothing more?
Against this.
Nothing more?
And not against 89 and 90. That was not even my case.
That the other case is compromise and 14.
And there's one more issue, just one issue. The building is standing in Schedule B and not on Schedule A. Now, my lord will see the fraud, my lord, page 272.
No.
My lord,
I am, you see, you have not brought in any other surfacey proceedings.
I have.
These surfacey proceedings under 23/12/2019 under no circumstances can be stayed.
Two pages your lordship will compare. 2 pages your lordship will compare, page 90 and page 270. Interpolation, my lord, interpolation, I'll show, my lord, page 290 and 270. Page 90 and 272 your lordship will compare. My lord, the building is at stake, my lord. For a moment, if your lordship.
I am not concerned with that, whether this land is, you have mortgaged 2/10 lectures.
But not,
This is not.
well, see these 2 pages, these 2 pages, my lord, 272 and 90. Compare, my lord, there has been an interpolation, my lord.
Interpolation,
272
whatever.
and it has, my prayer.
You are-
will
Let,
become
let,
the-
let it should go on, but you go ahead with initiation of proceedings under so and so. I think what we do, that taking into account your submissions in respect to 23/12, 23/12, let the suit go on, but I give you the liberty to go ahead in regards the initiation of surfacey proceedings in respect to the proceeding pertaining to the notice under 23/12/2019. He cannot say anything. He let him go and file a suit, but it shall not, under no circumstances, the civil court shall pass any order in respect to 23/12, which will be subject matter purely under the Surfacey Act, and it shall constitute a bar over that. As regards 23.
About the 23. That's.
I'm not on saying anything. You go and file the suit, we'll proceed. Let the suit proceed. This will be only limited to this.
Sir, here is an order of status quo. Unless it is vacated, we cannot go for that.
Where is the status quo order?
It is in.
Have you not challenged that order? Have you not challenged that order?
That is, but it is lying. It is lying. No hearing has been taken place.
You do one thing. Status quo, this is a huge amount, so it will come to me only. Can you file it within this week, next week, and appeal? I'll condone the delay and then stay there. Status quo. Better do that. Then his suit becomes infructuous. Unnecessary filing suits. Mr. Goswami, let me put this matter again on 24th of March. In the meantime, prepare an appeal against that order with the condonation application. I'll go delay the condonation and 24th of March.
No, we have already filed objection against the.
And there is a status quo order
Ah.
and there is a bar in granting a stay. In terms of section 34, there is a complete bar under this. You could not have done it, not under 18. 34, cannot be a grant of any injunction. So you take up that aspect and come before this. I'm sitting till 28. So immediately you come. We'll take it up and then on the basis of that, we vacate the status. Only to that extent that you can take action in terms with 2312 against that land. So then the problem is solved. Then let him continue, go ahead with the suit, whatever may be. It is, yes, as Mr. B.D. Goswami said, it's a case of clever drafting. This matter again on,
Matter may remain part.
it is. Matter having been heard at length, this matter again on 24th of March 2025 at 2 p.m. You file your appeal.
Item 10.
And in that appeal, you give that statement, categorical statement, that you are going to only do in terms with that 2312. Yes, what are you challenging?
But here my chance of written statement was forfeited.
Huh?
Written statement. But on the 90th day, after post the amendment, post the amendment of the day.
Submitted by the plaintiff that the written first time to filing the written statement. Written state, objection or written statement?
Written state, both.
Huh?
Both.
The written objection to you cannot.
A written statement was also already on record, Manoj.
Hello?
Was accepted, but thereafter.
What is the suit for?
For declaration of right title and interest, Manoj.
Regarding land, how much?
Confirmation of possession, Manoj.
How much land?
3 bigha, 1 kota, 19 lakhs.
Where?
In Manoj, Morigaon.
75,000.
No, the WS was already accepted.
Then?
Then they filed an application that it is beyond 90 days, then they expanded it. 6, 7, 21, 22 was the last 90th day ended. Lord. That day court was not there, we sought time. Lord. Next day we filed a written statement. Then they filed an application for expanding the already accepted written.
You are challenging the order in the 8-9.
Yes.
I heard Mr. B.D. Dekar, the legal counsel, appealing on behalf of. No. The court having accepted it, it cannot. One has to, no, whatever you mean. The court having accepted it, Mr. Counsel, once the court passes an order accepting it, it exercises the powers under section 148. So once the court exercises it, you cannot. The court cannot then again go back to what he has done. It will be reviewing its own order without an application. How can the court review this order? Heard Mr. B.D. Dekar, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent. This is an application filed under Article 227 of the Constitution challenging the order dated 8-9-2022. Passed in title suit number 157 of the 2021, as well as another order dated 8-9-2022 passed in MJ case number 83 of the 2021, arising out of title suit number 157 of the 2021. In the instant proceedings, it is a perusal of the impugned orders, which have, or the orders impugned in the instant proceedings, would show that the written statement as well as the written objection filed by the petitioners herein, who were the defendants in the suit, were duly accepted by the court, but beyond the period of 90 days. Subsequent thereto, an application was filed by the plaintiff that the said written statements as well as the written objection was filed pursuant beyond, after the period of 90 days. And in that regard, the learned trial court had passed the order dated 8/9/2022 in both the proceedings as referred to herein above. It is the opinion of this court that when the written statement having, as well as the written objection having already kept on record, and having been accepted and brought on record, the learned trial court ought not to have passed the impugn orders, thereby observing that the written statement as well as the written objection so filed by the petitioners herein, who are the defendant numbers 1, 2, 4, and 5, shall not be taken onto record and not accepted. Considering the above, this court therefore interferes with the order dated 8/9/2022, passed in title suit number 157/2021, as well as NJ case number 83/2021, arising out of title suit number 157/2021. Full stop. The written statement as well as the written objection so filed by the petitioners herein, who are the defendant numbers 1, 2, 4, and 5, the learned trial court is directed to take on record the written statement as well as the written objection filed by the defendant numbers 1, 2, 4, and 5, and thereupon proceed with the disposal of the suit in accordance with law. It is further seen that this court, by an order dated 5/12/2022, had stayed the further proceedings of of title suit number 157/2021. The said stay order is vacated and the parties herein are directed, and as the parties are duly represented before this court, they are directed to appear before the learned trial court on 9th April 2025 for further proceedings of both the injunction application and the suit.
Of course, maybe.
There's no cost. Here, normally I would have given the cost, but here the court having already accepted, you can't have. It is absolutely wrong.
Amen.
Yes, Mr. Shom,
May I please, your lordship?
what are you challenging?
Lordship,
Section 8.
Section 8, your lordship, covered
What
by
does
your
that mean?
lordship judgment, your lordship. Suit for recovery of area rent, your lordship.
So it has been referred,
Referred, your
area rent.
yes, your lordship.
So you want to go by Booz Allen?
Lordship.
You want to go by Booz Allen? Booz Allen judgment.
Lordship, your judgment, your lordship judgment.
My judgment follows Booz Allen only.
Lordship.
Yes. Isn't it Booz Allen's I have referred?
And later also.
Idiot role here.
That only the your lordship clarifies who's available.
No, here it comes under the Rent Control Act.
Yes, there are two submissions here.
Vidya Rolia says that when there is a statute in that regard, then under such circumstances, the question of the arbitration would not come. That
And special,
special.
and special. That condition is to be satisfied. And second, your lordship is whether this subject matter or whether the land or the property falls under the urban area. That has to be, because whether the urban rent control area is applicable to the, where the property is situated. That has to be the, because from a bare reading of the plain, as well as to the objection to the section 8 petition, there's not even a single statement to the effect that the land area falls under 2A or 2G of the urban rent control area. So there cannot be any presumption that the urban rent control act applies to them. They fail to discharge that presumption.
Where is the property?
It is in Makpum Kila, and as far as my research is that it is a forest village.
It is near 6 kilometers near Mamreta.
Hmm.
But there is no mention by them that it falls under 2A or 2B. The first submission, in fact,
So you say the Assam Urban Area Run Control Act would not come in?
not come in, or your lordship, since they have failed to mention in their petition.
Hmm.
Now whether the referral clause would just limit itself to the existence of the arbitration agreement, or whether they would go into a mini trial of evidence and all. And leave the jurisdiction to be decided by the arbiter under section 16.
Where is the arbitration clause?
Clause is your lordship. There are two petitions. First petition, first two agreement rather, page 18, the clause is at page 31. It
The
starts,
land is at Guwahati, in Tinsukia.
no, the district is Tinsukia.
Land is in Tinsukia.
But place is Makum Kila, forest. Forest area.
And how are you having it in Pune jurisdiction?
Pune is the defendant's office.
You don't have an office in Pune, your office is in Mumbai. Then how are you having that jurisdiction for? Arbitration will be at Mumbai.
That should come, if
Person will fight out there in Mumbai.
sorry,
A person will find out in Pune for eviction. I think this is a high time, right?
the
Deferred, no?
place of it.
We
Your lordship,
interfere
the
with
parties can agree for venue here also.
No, I think we should interfere with this type of matters. Heard Mr. A. has shown the learned counsel appearing on behalf of the petitioner, Mr. Ashwani appears on behalf of the respondent. This is an application filed under section 115 or 227,
2/7.
the article 227 of the Constitution challenging the order dated 23/8/2022, whereby the application under section 8 of the Section 8 of the Arbitration and Conciliation Act 1996 was allowed. Thereby, the suit was disposed and the matter was referred to arbitration. This court have duly perused the copy of the plaint and from a perusal of the plaint, it is seen. But it is a money suit.
That is my second argument about it.
Recovery of area rent,
They have not paid for even eviction.
Oh.
So if it is a simpliciter money suit, whether the Assam Rent Control Act will come into play. So that is my second submission.
page 37,
In that regard,
my prayer.
There is a problem arising.
And during pendency, the existence of that deed, your lordship, that deed is also not registered as per the party.
that issue has been decided, your lordship, by the
No, no.
place as well.
That this court have duly perused the money suit, the suit so filed by the plaintiff. And from a perusal of the said suit, it will be seen that the said suit is for recovery of certain amounts which the plaintiff, the petitioner herein claims to be the area rent which the petitioner is entitled from the respondent. This court further have also taken note of the lease deed executed on 13/6/2028, 2008,
In subsequent. You on 16,
which
11.
is not in fact the lease date dated 13/6/2008, wherein a premises being a premises at measuring 352 square meters was rented out to the defendant, to the respondent herein. Was taking into account that the suit was not filed for eviction, but is a suit only filed for recovery of the amount. This court finds no reason to interfere with the order passed by the learned trial court dated 23/8/2022, passed in case number 12/2022. Accordingly, the instant petition stands dismissed. Finds no merit for which the petition stands dismissed.
Okay.
Well, the file proper suit.
Oblige you.
Yes, Mr. Ali. What is it? Landlord tenant?
Yes, my lord. This matter, this is going to like first date, your lord. My second is on check.
Not necessary. I dismiss in the motion stage. also.
Any date in the month of April, your lord.
Both counts? Both counts?
Both.
Means the defaulter,
Dangerous defaulter.
Not so, your lord.
finding of fact,
My lord.
finding of fact.
I think my fact is about the landlord.
What is his stand?
My lord.
What is his stand?
His stand is, my lord, that it's not a default.
Why?
Because instead of paying 18,000, he is paying with 5,000. And that too, he claims that he has deposited, but no deposit.
Huh?
No deposit.
No deposit also.
No deposit.
What is the, let us see the
Rent
finding
was-
of the. Well, trial court, so and
Lordship,
so.
actually, with him, there is a deposit of rupees 7,50,000.
Wrong, sir.
That 7,50,000, your lordship. Is lying with him.
Wrong solution. Wrong solution.
Records have also come. But there is a security amount lying.
That has already been returned by.
So security amount, your lordship, 3 lakhs.
Huh?
3 lakhs,
So 3 lakh, 2,50,000.
still lying with him. And in repairing the,
No, no, that is a finding as regard issue number 4. Issue number 5,
No
issue
finding,
number
Your
4. No, issue number 2. Issue number 2, the learned first appellate court comes to a finding, paragraph 22, page 104. The check was taken back by the defendant and the plaintiff also did not encash the said check. The plaintiff has proved that the check in his evidence as PW4. Therefore, it is found that an amount of iman lying with the landlord as security according the issue is decided. But was the check encashed?
By me, no.
Then how 2,50,000 has been held to be lying with you?
My lord, check was given, but it was not encashed.
So then why does he say the check becomes non-negotiable if it is not encashed?
Yeah.
He only produced the check.
No, check was given at the time when he entered into the tenancy with me in the year 1994, 84.
But the check was never encashed. Then how do you say about the issue number 2, page 105?
Whether the defendant has paid a sum of rupees 3 lakhs as security deposit to the father of the plaintiff. In this respect, evidence of the plaintiff is that the defendant at the time of executing the tenancy agreement paid a sum of rupees 3 lakhs by way of check. Out of these, there was a check of rupees 50,000. It has been deposited by PW1 that the defendant assured that he would take back the check for rupees 50,000 and would make the payment in cash. However, the said check was not taken back by the defendant and the plaintiff also did not encash the said check. The plaintiff has proved the check in his evidence as Exhibit 4. Therefore, it is found that an amount of 2,50,000 lying with the landlord as security deposit. Accordingly, the issue is decided.
Huh? How do you challenge this?
2,50,000, my lord, I have already said that at the time, because that was a security, the moment he will go out from my premises, I will give it to him. That I have already mentioned in my complaint also, my lord.
So that means you admit to have the 2,50,000 as security.
Yes, yes, at the time of entering into the agreement, my lord, he gave me that. Yes, but that was a security amount, not to be adjusted, not adjustable amount against the rent.
And bona fide requirement?
My lord, issue number 5. At page number 106.
Chalo. Okay. When do I dismiss it?
My lord,
When do I dismiss it then? Okay.
today it can be because he is the
pardon lordship,
When do I dismiss it?
lordship, matter may be hard, your lordship.
There is nothing to hear.
But it-
These are matters to be finished.
It is in dilapidated condition, your lordship. Was everything, your lordship, were not in it. So, with your
Mr.
consent,
Ali,
your lordship, I spent.
Mr. Ali, those
I bless
those
the-
things hardly matter.
No,
I'm
that
not
is my
concerned.
fault, your lordship.
When should I dismiss it? Let us dismiss it on
I bless
25th
the
of March.
of your lordship, and they are-
Is the matter on 25th of March at 2 p.m. We finish it off on that day. Taking into account that the records are already.
So on that, your lordship, at least I may be hard, your lordship. I will convince your lordship.
I'm giving you time on 25th of March at 2 p.m. I won't be passing the judgment immediately. I will ask you, what do you have to say?
No, before dismissing the lordship, I have a right to argue.
Definitely,
But I will convince your lordship.
definitely, that means I put it on 25th of March.
Lordship, whatever I expect that has not been considered by both the courts, your lord. That is 5 lakhs at that time, your lordship, 2003, your lordship. And it was not in habitable condition. That is basically a lodge, your lordship, not hotel. They are saying it is hotel. That was a lodge.
We are not on that
It is
aspect.
not a good condition, so I had to repair.
You want this court to take it up now, Mr. Sali? I have time.
No, no, your lordship. today-
No,
today
no,
I am
if
not
you
taking-
want, I can take it up
taking
now.
up-
I give you time
Lordship,
for 15
legal
minutes. I have the
private
records.
decision, sir.
Mr. Ali, these type of matters doesn't take much time. These
Sir,
matters,
it is not
these
20.
matters does not take much time.
Lordship, 20.
25th at 2 p.m. 15 minutes argument, then 15 minutes judgment.
13 and 14.
What is this review file?
Case lordship,
What is wrong with this order?
the order itself says it's a walk-up property. Admittedly, this is a walk-up property by the plaintiff and the defendant also, lordship. And thereafter, lordship, the suit was declared, our counterclaim was dismissed, lordship. So I prefer two CRP, lordship, under 115. Both the CRPs were disposed of directing to file first appeal, lordship.
Ah.
When it is a lordship walk-up property, no appeal lies, it is settled position of law, lordship.
Appellate court on determining the. What is this? Is this something? You are appealing? This is an appeal under 115. Appeal number, it's a revision. Review. Review. By the petitions were directed to file against the judgment in the brief faster in month. You are asked to file?
First appeal before the district judge, lordship, before the first appeal court,
Against,
against the decision given by the municipal court, lordship.
then
I have not preferred any appeal, lordship, I have filed the review.
why?
Because lordship, in the walk-up property, no appeal lies, as per section 83.
Walk-up property, the suit also does not lie.
Yes, lordship.
Then-
For that only I have challenged it under 115. Divisional court has jurisdiction, lordship.
No, no, no. First of all, why did you file the suit?
Filed by the plaintiff, lordship. Respondent number 1.
And-
For declaration of tenancy right, lordship.
The declaration of tenancy granted.
Yes, yes.
If the tenancy has been granted, the court had exercised the jurisdiction. An appeal there against will be the normal appeal.
Walk-up property, it is admitted by the plaintiff and defendant. Mutawalli later on pleaded, he filed his written statement that it is.
It-
a walk-up
Your appellate ground would be that the court did not have the jurisdiction. Your appellate ground would be that the court did not have the jurisdiction because it's a walk-up property. Because isn't it the bar under 83 of the
property. It is 9 there is a bar, lordship.
83 days a bar. So your appellate ground would be that the learned trial court did not take into consideration.
His lordship after.
But objections are raised and thereupon you can very well come to the second appeal also if I'm keeping on sitting out here, if that is not heard. But the fact remains of that you can't come under 115 if it is an exercise of jurisdiction by the munsif. I would have understood, but munsif has not been given the power to exercise the power under wakaf. The power is being given to the labor court, if I'm not wrong, or the wakaf tribunal is the labor court, isn't it? So under such circumstances, this review doesn't arise.
And saying that lordship, that judgment passed by the municipal has to be set aside by this court, otherwise lordship is.
How?
If I.
Why will this court set aside under 115 when there is an appellate authority?
Direction given in the CRP.
Rightly so. You should have filed an appeal there. So, and both the this is
Against, one against the declaring of the suit and one against the counter dismissal of the
Alright.
counterclaim. We have filed counterclaim, lordship.
you filed a counterclaim also.
Lordship. For
Like,
eviction of the plaintiff.
both these review applications have been filed. Challenging the order dated 13/12/2023. Whereby Now, both these review applications have been filed, seeking review of the order dated 13/12/2023, arising out of CRP number 177/2023. The ground of review so taken is that as the property in question was a worker property, there was no appeal lies against a judgment and decree passed by the learned court of the Munsif. Number 1, Korimganj. And as such, the petitioners had filed an application under section 115 of the code. The said submission so made appears to be totally misconceived and untenable, taking into account that an appeal lies against the judgment and decree passed by the Court of the Civil Judge, Junior Division number 1, in title suit number 200/2016, before the appellate court in terms with the Bengal Assam Agra Civil Courts Act 1887. This aspect of the matter was duly taken note of by the coordinate bench of this court dated 13/12/2023 in CRP number 177/2023, thereby granting permission to the review applicants herein to file the under such circumstances. Ms. R. Chaudhary, however, submitted that as the tribunal, as the court, as the learned Munsif did not have the jurisdiction, as the property was a worker property, and before parting with the record, this court finds it relevant to take note of the submission of Mrs. R. Chaudhary, who submits that as the property in question was a worker property, and appeal therefore there was no appeal against the judgment and decree passed by the learned court of the Munsif, Civil Judge, Junior Division number 1. It is the observation of this court that the learned Munsif, learned court of the Civil Judge, Junior Division number 1, having exercised the jurisdiction which is otherwise outstayed, may at best be a ground of objection taken in an appeal. But however, that the same would not give them a jurisdiction for the purpose of filing an application. Before parting, accordingly, the review petitions them. You have been given time, now you have to file. So all these things. 15.
13, 14, same, only the numbers are different.
Number change to.
Apply.
What is this, Mr. Sikdar? What are you challenging?
It was heard on earlier occasion. When we are
Oh, that case.
this case, my lord, our grievances against the impugned order at page 23.
Mr. Sikdar,
While IFR condemnation was filed with the false statement. They said that they have no knowledge. till
Mr. Sikdar,
27.
I'll fix this matter on 2nd of April because my conscience does not permit to allow your petition. Leave this matter on 2/4/2020. I can't help it.
Well,
In my opinion, the trial court was justified.
16.
Yes, Mr. Shah. What is this you are challenging? What are you challenging?
Against an order passed by the trial court rejecting to pass a decree on admission. Second order is page 116.
Oh, this is some typical case where matter came up once before me. Isn't that the case? No, it never came before me.
First for cross-examination in English language.
This one?
There are two suits. One of the two.
Okay, what are the facts here?
Well, here in this case, plaintiff has claimed that there is joint property of the plaintiff and defendant both.
Ah.
And both property were given to for cultivating to some person. And from that person, they get paddy. Annually, they get paddy from that person. 3 months per biga. There was 3 months per biga, he is getting it. So here is the query that
You are the plaintiff? You are the plaintiff?
I-
So your case is that you filed an application on the order 12-6 for the purpose of
I have plaintiff has filed a petition.
seeking a decree on admission. Have they admitted?
Filed a- That is, I am saying,
Where is your plaint?
my lord, my lord, the petition is for decree with regard to some of the prayers.
Ah.
Some of the prayers, my lord. The petition is as page number,
So you want, now have they admitted everything?
they have admitted that this is joint property. They have admitted that yes, we get shares equally. They admitted that we get shares equally. They have admitted joint property. They only say that it was not at the rate of 3 months per biga.
Hmm.
It may fluctuate. He said that it is not 3 months per biga, it was fluctuate. Otherwise, regarding position of property, regarding ownership is admitted. So, my prayer is, my lord, in the petition, my prayer is only, they are responding, they are dependent number 2 and 3 also, my lord. Dependent number 2 and 3 are the person who are cultivating the land. 2 and 3 are the persons who are cultivating the land, and they say, they admit that yes, the agreement is 3 months per biga, 3 months per biga. They admit it. So, my prayer, my lord, my petition is page number 75, my lord.
Your prayer is page 27.
My petition, my lord,
What do they say in their written statement?
page 75. with them.
Where do they admit that you are entitled to
In this
50% share in the respect of petty received?
my lord, in this petition, my lord, I am praying for.
No, Mr. Sharma, where in their written statement they admit that you are entitled to 50% share in the respect of petty received?
That is WS, that is WS.
Where?
WS starts from page 33, my lord.
There is no agreement with the defendant to pay 3 months per biga as per land, as entire land is not cultivable. Majority of the waterlogging, hence asked to pay 1/3 property product of the petty, and there was no agreement to fix amount of petty. Then where is the admission?
There is one going on. There is a going on. That page para 6.
Para?
Para 6, my lord. It is not true that Tilak Purva cultivated 16 biga, 4 kata, 2 acres of land, back number such and such and such. So after collecting, last 2 lines, after collecting the paddy, total 1/3 are divided in granary of the defendant number 1. Subsequently, only half portion of land is used for cultivation, hence every part. Then, after death of Tilak Purva, what, next para 7, what they said, it is true that whatever the product, they are directed to pay 1/3 share. Thereafter, every year, cannot
So
provide.
they are on to 1/3, you are seeing 50%.
No, 1/3 we receive, he said that 1/3 we receive from the cultivators. And whatever we receive from cultivator, we divide it equally.
Where is that statement?
Then para 12 may come, para 12.
Where?
Para 12.
And
Statement
he
para
is not
12.
agreed by the
Whatever
defendant,
petty is
whatever
delivered
petty
by
is
the
delivered
defendant
by
2 and 3,
defendant
same are
the
divided
same
into
are
two parts
divided into two
and
parts.
kept in guarantee of the remaining one.
Kept in the
So the
guarantee
plaintiff, whatever comes, take his share, petty and
Plaintiff, whatever comes, takes his share of it. Whatever, it
But-
is not done, that we give you 50%.
So, well, 50% of whatever is given to them.
Not 50%, whatever he comes, we give him something. This is like.
My lord, this is his, here he is admitting that,
Oh, Mr. Sharma,
my
not
lord,
50.
what I'm saying, my lord, here he is
There is
admitted
no
fact
point
that,
stay. You want to withdraw the suit
no, my lord,
in view of the
my lord,
admission.
whatever saying that, he said whatever amount you receive for
No,
whatever
when
petty,
the trial court had not come to a finding to the effect, you see, paragraph 13.
say that, my lord, whatever petty we receive, we divide with two brothers, divide 50/50.
Judgment and so and so.
Then the
Or
defendant got 2
Mr.
and 3, my lord.
S.J. Sharma, the learned counsel, petitioner, Mr. L.P. Pupasti, appears on behalf of the respondent. This is an application filed under Article 227 of the Constitution. 227 or 115? 115, huh?
150. My lord,
115
kindly
of
see
the
the
code.
defendant 2 and CWs also. They admit that they are cultivating, they admit that they pay petty at the 1/3, 1 bigha, 3 months per bigha.
Hmm.
They are admitting that.
Hmm.
So my prayer is that from this year onwards, let the petty my share of petty may be paid to me together. So according to admission of defendant 1 and 2,
You are asking for specifically a decree for recovery of 140, 144
no,
months.
that part may not be given at this
How,
stage.
how is it possible? Did you say that you don't want these?
No, at this stage, my lord, that the degree may be,
No.
part degree may be there. But degree on admission may be on part
See,
also, my lord.
this is not a suit for
No, no, it may be on part also, my lord.
Mr. Ajay Sharma, the learned counsel appearing on behalf of Mr. L.P. Pupasti. This is an application filed under section 115 of the Code of Civil Procedure. Challenging the order dated 28/5/2024, it passed in the case number 11 of 2024, whereby the application filed by the petitioner with the plaintiff in the suit under order 12/6 for seeking a judgment on admission was dismissed, rejected. This court had duly taken note of the claim as well as the written statement and the impugned order. For perusal of paragraph number 8, 7, 8, and 9, it transpires that the suit, this court have duly perused this court have duly perused the claim as well as the written statement so far. In addition to that, this court have also taken note of that the learned trial court have duly considered the pleadings of both the parties and also the provisions of law. And in that regard, had categorically opined in paragraph number 13 of the impugned order that mere admission of the defendant number 2 and 3 would not be sufficient to pass the judgment on admission. And there are materials that need to be adjudicated, and without such deliberation, passing of the admission decree at this stage would not be appropriate, as the parties and others, if any, interested in the suit would be prejudiced of any relief to be decided on merit. Also, taking into account the reasons to assign, this court finds no ground to interfere with the instant proceeding, to interfere and exercise the revisional jurisdiction of the court. Considering the above, the instant petitions stands dismissed. There is no stay.
Yeah, there is no stem, my lord. Much obliged.
10.
I'm appearing for the
Put your name, we put it in golden letters. Yes, what is this?
We are challenging one concept.
How much?
Two vehicles, awarded amount of 35 lakhs.
Huh?
35,20,261. Two vehicles are involved in this accident.
35 lakhs. Why you are challenging the quantum?
There are two vehicles are involved in this accident losses. One was driven by the victim motorcycle as per GB entry, he had suddenly stopped the vehicle for which our vehicle could not control and
So you are saying on contributory negligence.
Your Lordship.
So for the purpose of contributory negligence, did you plead that? Did you plead contributory negligence or not?
Our vehicle was not offending, Lordship.
No. Did you plead contributory negligence? If you don't do it, then it cannot be given. This is a very recent judgment of the Supreme Court. You must have looked into it. Very recently, around 2 months, one month back. There's a specific judgment on this point that if you don't plead contributory negligence, you cannot get it. Don't it?
What is not there in our pleading? Lordship.
Not word. You should say that this court, even assuming that we have done something, something has to be given.
Our plea was that our vehicle was not fully responsible. Lordship. Due to sudden stopping, our vehicle had hit his vehicle. That is why the accident.
And the court gave you why the entire amount.
As per search sheet, Lordship.
Huh?
As per search sheet, our vehicle was held liable, Lordship.
As per
Search sheet.
charge sheet. Okay.
And another regarding Lordship income, the one clerk of the LSP estate where the victim was working was examined, but he did not produce any authority letter from the concerned minister.
Whether the document was enough, what did you do? That person concerned?
He was elected to one clerk of that tea estate, but his neither authority letter nor his identity card were exhibited in the court to prove that he was actually working in that tea estate.
Did you argue that he had no authority?
His procedure is not made on that point. He had admitted that he.
How much did the court come into?
40 is 40,000 something, Lordship.
And as per how much it should have been? So what was exhibited? Exhibit 12 is the salary certificate.
Yes. Lordship,
Those salary certificate, even certified by the senior manager. Had submitted the computer generated areas by certificate by year. From the Iman and Iman, if the deceased was drawing gross salary of so nothing wrong there. Hello. Who are you?
I am for a claimant, madam.
Ah. The issue note. Appeal admit for people. Stay subject to deposit of 50%. 50%. And the claimant will be entitled to get the release. It is like it, and when they file an application, so at the line, upon perusal of the records, and after it is however observed that as to whether the petitioner hearing was appellant insurance company is liable or Reliance, no?
Yes.
Respondent number?
I am appellant.
You are Reliance. The other one? There's an
Other victim of this party. He was owned by the victim himself. He is even.
whether that person's name is respondent, other owner, you have not made him a party. And you did not raise anything.
There is our view of clear law that non-resident parties were there. The vehicle was driven by him, and that was not made.
The question as to whether no, it is observed that and what was the other car? What was the other vehicle?
That was also one motorcycle A02 A5109.
And what was your statement?
think that our vehicle is not totally responsible.
No, your paragraph number 6 is different. Yeah, 50% it is.
Apply.
Can't put that word also. You have not mentioned anything in your written. I suppose, severe discharge. You take that money.
But claimant may be allowed to do that.
I've given it.
Apply.
18.
I think 18 lordship connected case lordship had admitted on lordship last Friday lordship.
Which one?
MSC appeal 78 of the 25. It analogous matter connected case lordship.
For there, without interest, I have given, na?
Permit.
I've asked you to pay without interest.
9% lordship. Whole amount has to be paid. And that time pain and suffering is not allowed. But here, there is no plea for pain and suffering.
Lordship, in that case, permit defense we have taken lordship.
Permit.
So permit defense, so lordship had allowed us to, directed us to face entire amount except rupees 30,000, which was given in the head of loss of amenities lordship.
Yeah, loss of immunity, 30,000 given.
10,000 only.
30,000.
30,000 is given.
30,000.
Those amenities is 10,000 lordship. In that case,
Mr. Agarwal, come to serial number 8. Of paragraph number 52.
Yes, lordship, 30,000. Then on, in that case also 30,000. That amount, except that amount, everything was related to be paid by us.
Itu koi dibo, na?
That is
And there is the question of without permit, na?
permit.
What is the number?
That number MSC appeal 78 of the 25. And IAS bill.
25. I will log on IA.
IS civil 668 of the 25. IS civil 66825.
It minus 3,55,737 plus interest at the rate of 9%. 6 weeks. He order to Mr. Saidiba. Ali, I'll hit that liquid issue. That it hoy, Punaro logo.
claimant may kindly be left to.
Yes, you withdraw.
Okay.
I did. You don't need to file application.
My own brother in
You want to file application?
Limited item 50 to 55.
Yes, what are these?
The privacy. Take up the first item number 54. 54 may be taken back. Item number 54.
What are you challenging?
But my reference case has been dismissed lordship on the ground of delay and
Delay. Why?
lordship kindly see case 28.
Hmm.
Garnet court will also reckon the delay from the date of declaration of the award.
Hmm.
Actually, it ought to have been lordship as per section 18(2) of the act lordship. Wherein lordship within 6 months from the date of within 6 weeks from the date of notice and from within 6 months from the date of collector's award. Lordship. My case is lordship, we have filed our case within 6 months from the date of collector's award. Collector's award from the date of receiving award. Lordship.
You have filed within 6 months.
Yes, lordship. Kindly see lordship, we have arranged all our documents lordship.
You are referring to section 18(2). 18(2) says about two things. First thing, if you have participated in the proceeding, then within 6 weeks.
Yes.
If you have not participated, then 6 months from the date of the award.
Yes.
That's it. And you filed within 6 months.
Yes.
Did they file within 6 months?
No, that's it.
We do one thing. How many matters are there here?
6.
Huh?
6. No.
6. We do one thing. We'll take it up tomorrow
Sure.
at 2 o'clock.
Sure.
Take it up tomorrow. You find out. But if it is so, within 6 months, we immediately allow these appeals and limit it back to the reference court to decide. Because delaying this matter out here, later on referring it, would have huge repercussion as regards interest. Okay? You look into it. Okay?
19.
This matters again on tomorrow at 2 p.m. Mr. T.R. Gogoi appearing on behalf of the respondent state shall obtain instructions. You just look into that, whether it is within 6 months, that's all.
19.
And there are 2, 3 judgments also. One is of Justice Barucha in that regard. There is one judgment of Justice Sema earlier, that is 2003, some judgment. There is another judgment of Justice Barucha later on, 2004 and 5, which permits that it can be done there also, and Section 5 duly applies.
So in this case, Lordship, we filed reference before Deputy Commissioner. And Deputy Commissioner also referred the case to the larger court. In the improved order, there is no any whisper about the Deputy Commissioner's order, whether it is time part or not. But
You,
that is to be
you
considered by the
prepare the
Deputy Commissioner
dates
file.
when you filed that application, when the award was passed. Okay? And as to whether you participated in that proceedings. Yes, next, RSA.
Hearing under order 41, rule to CPC.
Yeah, you don't have a case.
May I please, your lordship, please, she's on legs on another, your lordship. Let me call her.
You don't have a case.
I'm calling her, your lordship. Give me 2
Does
minutes.
he have a case? Concurrent finding is not the question. I don't have a case. It's a suit for specific performance. No, what was that?
They are claiming that they have acquired tenancy right over the.
Tenancy right. Tenancy. And claiming adverse position.
Corporation, but adverse position of.
Tenancy under whom?
that
You.
is not-
The tenancy under you.
Tenancy under,
Tenancy under you and he's claiming adverse position.
but adverse position is not stated. Adverse position is not stated.
Let me call her, your lordship. And then 2 minutes, your lordship.
Have you gone for execution or not?
Instructed them to go for execution. but
Go. Mr. And it is seen that the counsel appearing on behalf of the appellants have been taking time in the instant proceedings right from the year 2023. So whenever the matter is being taken up, the counsel for the appellant has expressed inability to argue. It is under such circumstances, this matter after 4 weeks, it is observed that the filing of the instant second appeal before this court would not amount, say, to the execution of the decree. Who has filed the suit?
They have filed.
You filed a counter claim. Not amount to stay of the execution. The executing court would be at liberty to proceed with the execution of the decree passed in the counterclaim in accordance with the. Yeah.
20,
You have a bad case.
But still it cannot be taken up today, because the name of the counsel appearing for the defendant is not appearing.
We don't require defendant. I don't ask the defendant. I'm asking you. You don't have a case. Why should be I hear? I normally don't hear.
Document, my lord, that they have relied on. Which I have denied, my lord.
Quote the courts below categorically hold that exhibit
it
2
can
have
be
been
acted upon.
proved. Exhibit 2 has been proved. Now your case is that this could not have been taken into account in view of section 17 and 49. But section 49 says that any other, that document can very well be taken for the purpose of collateral purpose. Now, normally an agreement for sale or a sale deed without there being it being registered, it may not be taken into account. But the fact that the evidence on record categorically show that you have entered into a verbal agreement, and in pursuance to that, this sale deed was executed and given it to you is a fact to show that there was an oral verbal agreement for sale.
No, that
And this has been
agreement
duly
needs to be
admitted.
signed by both the parties, my lord. That if it is a contract, that agreement has to be signed by both the
Not
parties.
necessary. How many,
It-
how,
it-
Mr. Goswami,
it-
recently nowadays you find agreement for sale, last 10 years only, wherein agreement for sale require mentions out there that, what you call, agreement for sale only mentions to this effect, what you call, the vendor vendi or whoever it is. Seller, seller, vendor, all these things. But earlier, it is only the vendor who signs it.
Earlier, man. But my lord, your lordship will see, this is the document that they have relied on. This is a-
Exhibit 2.
and,
And you
and-
can, you have proved that exhibit 2 by bringing your own witness itself. Okay,
my lord,
you have taken 1,40,000.
my lord, that 1,45,000 not for the purpose of, my lord, this land.
You
There was
say
a
that you are
family
in-
partition on this land, my lord.
From your written statement, it is also clear that your specific case in the written statement, yes, I have taken 1,40,000.
Not for the.
My brother came out, asked me to sign some paper. I said that I am not going to sign. Then he took back the 1,40,000 from me. Then I needed, because of my illness, I took that and signed it in blank paper. They have converted into
Blank paper, my lord. This was
That-
not there.
that is what you say, that you have signed it in a blank paper and deconverted into a sale deed.
Fine.
But the fact that the two witnesses who were there, whom you brought in, have categorically proved this aspect, and this is a finding of fact.
But still, my lord, if at all it is to be acted upon as an agreement to sale,
It is not an agreement for this,
is
would not
neither a
be
sale deed, my
considered
lord.
to be an agreement for sale. This puts an emphasis on the verbal agreement for sale.
my lord, that is, that
Fact
is,
is, one thing good about you is because of the earlier matter being taken time by you, not taken, you have been able to stall this court from dismissing it today for lack of time.
my lord, let it be listed showing the name of the council. My lord. The
Who's-
name of the other side is.
Mr. Goswami, kindly, let me tell you. Don't shame this court or embarrass it. I am not going to hear the respondent. Unless he is on KVM. People will laugh. Because they say, what is happening to the Guwahati High Court? Hearing the respondent counsel for the purpose of framing substantial questions of law.
So another day,
Tomorrow, day after,
as your lordship.
list the matter, পড়া হয়ে আছে. I think.
After the holy, my
require
lord,
much.
Monday,
Today is Monday, we have it on 12th. I think we should finish it up before Holi.
after holy. After holy.
Okay, I'll leave the matter on 19th of March.
March of May. They are from Borpeta, man.
Huh?
They are from Borpeta.
Okay. Any extension of orders?
I've got matter if your lordship permit.
Hmm?
Lordship permit, Lord.
Yes.
Item 44 and 45. But this matter was listed at our instance, Lord. Here, one of the respondent had expired.
What to do?
And it appears in that matter.
Who appears? Hearing. Why this is being enlisted today?
But we had made a mention, your lordship has permitted, I was sought for orders, man. Has come for hearing because that was admitted. Respondent number 2 had expired, Lord. Which one? 44, 45.
Who mentioned these matters, hearing matters before me?
But I had mentioned.
Did you file an IA?
No, but I had filed. But I had filed an mention memo indicating to your lordship that the
Oh,
respondent.
you wanted to
Yes,
inform?
yes, yes.
Okay, when did they die?
25/10/22.
When?
25/10/22.
Who died?
The respondent number 2.
And then number 2 died on
25/10/2022.
25, 10,
2022.
2022.
Yes.
And the other one,
Only one.
respond number 5.
Respondent number 2. 1 and 3 I am appearing
Okay.
and the legal
Mr.
hearing.
Ardube submits that submits that in terms with the provision of Order 22 Rule 10A of the code, he would like to inform that the respondent number 2 expired on 25/10/2022. Taking into account the above, it would be deemed Mr. Jed Mukit, appearing on behalf of the appellant, submits that he had no notice of knowledge about the same. So taking into account the same, this court observes that with effect from today, it would be deemed that the petition, the appellants herein have knowledge that the respondent number 2 had expired on 25/10/2022.
But I'm furnishing the details.
Very good. Do whatever you like. That is between you and him. Mr. Jed Mukit submits that he would like to take appropriate steps. He is at liberty to do so.
Both these cases.
My lord, I beg to item number 38, my lord. I have interim order, my lord, and other side already appeared. Item number 38, my lord.
38. Oh, this 38 is such, well, that written statement.
I have filed my 38
Written statement, how much time did you take?
5 years. No, my lord, there is,
Yes,
your
5
lordship
years.
already given the assertion. I have not received any summons, my lord, from the lower court.
Lordship, they
That
have
is
been
the fact.
filing Hajira in the title suit. In the title suit, they have been filing Hajira continuously. And they say one day, one fine morning, that Hajira has been filed without wakalatnama. And
We are not saying this.
that-
This is
yes,
saying
it
the
is in
court,
your
my lord.
pleading. Just a moment. It is in your pleading. Then what happened, Lordship? It
Let it
has been expertise. Without vacating expertise, they have come before this honorable court. Expertise has been vacated there, the lower court below.
Vacated.
No, not vacated.
My lord,
Okay, item number 38 leaves the matter on
It is not 26, Lordship, because
26th of March.
yes, Lordship, because outstation advocate is coming, Lordship, I should be highly organized. I am just an engaged counselor.
You want outstation counsel for this?
No,
one?
he is the main counsel there. He is the main counsel. He's coming from Silchar Kachala.
Fantastic. You should also have a taste
I
of
have
this
no
one
problem. I have no problem.
on 26th,
26.
26th March
Sure.
at 2
Interim,
p.m.
interim order pass earlier.
Interim order passed earlier shall continue till then.
Obliged.
Anything more?
Lordship, I beg to pray before, item number 28, Lordship.
What is that? CRPI.
Lordship, kindly fix this matter, Lordship. Lordship, kindly fix that, Lordship. All the respondents have already filed their Ukalatnama, all the respondents, Lordship.
Wakalatnama filed.
Yes, Lordship.
The 28 to service being completed. List the matter for admission next week.
Give me a
And
break.
next to next week, in the week commencing from 17th of March.
Give me a break.
Item 42, my lord. I have held two IA, my lord. One is for implement and another is for stay getting.
And
One is for implement, another is for getting into a stay, my lord. That may be.
vacating the stay.
Stay.
CRP, what is that CRP for? Landlord tenant.
I am the owner, my lord, and the purchaser and owner, my lord. They have not made party in the CRP, my lord. But in interim order has not obtained, my lord.
You are the owner
Yes, my lord. I am the
now.
owner. Yes.
Now, earlier also.
Now, at present, my lord, I am the owner. I have not been made party, my lord.
And where you are partying before the trial court.
But in that case also, I have not been made party, my lord.
So, what business you have now?
I want to implement in that CRP, my lord.
Okay. Item number 42, listed matter on 21st of March 2022, 25. Liberty given to the counsel for the parties to mention the matter for upgrading.
Fine. Thank you.
Anything more?
Item 37,
Ah.
I have taken step upon respondents. There is an interim order.
7.
Your Lordship, I have paid,
You are paying for everybody?
37.
Okay, what is the
I
matter
filed
about?
Ukalatnama.
Huh?
Ukalatnama I have filed.
What matter is this?
Yeah, regarding your Lordship, closure of his WS.
WS, okay. When did they fix the earlier WS? How much time? After how much time the WS was closed?
Just close after
He filed WS. After 90 days.
after 90 days.
That I know, obviously. How much after that?
I have engaged here, I am not in the track.
I will not count it, Lordship. Okay. Just,
Then no extension of interim order. The service being complete leaves the matter on 21st of March 2025 for admission. Interim order, you don't know what you are saying.
Item number
I
30.
can't help you.
Item
You
number 30.
don't come before the court prepared, I can't help you, Mr. Counsel. Okay, interim order to extend. Yes,
Item number 30, interim order was
13, 13.
30.
What is that?
The transfer petition of guardianship case.
Anybody appearing there? You have not taken steps.
No, Lordship, they have appeared, but
Somebody appearing?
Lordship.
This item number 30 leaves the matter again on 4th of April 2025. Interim order passed earlier shall continue.
Possible.